welcome to you on Zoom. I am still, there's the camera, so I'm going to try to figure out how to look at the camera and look at all my people in the audience. We have about a minute before we begin, so I'm kind of testing the waters. So let's see here. For the Zoom folks, there is a chat box I will attempt to look at, but I may overlook it. I will also try to remember to repeat questions, and hopefully that'll work out for you. And we'll see how this all goes. My first hybrid meeting, so I'm glad to have all you people here in the audience live. That makes it much nicer for me. The Zoom, I've done this a couple times on Zoom only and didn't love it. Sitting at my desk, which was nice, but sitting at my desk staring at my screen was not as much fun as looking out over a live audience. So welcome to those live and to those Zoom. I'll do my best again to try to make it as entertaining as possible. All right, it is 9 o'clock. I'm going to do the sponsorship welcome and thank you. So I would like to let everybody know that this seminar has been sponsored by Waterview Title Services. So I'm going to let them have the floor. Hello, everybody. John Lack with Waterview Title Services. Welcome, and I hope you enjoy the show. We have food and I guess there's drink in the sense of there's coffee and waters, but there's food out there for you. I hope that's all good. Waterview Title Services, it's changed a little because of COVID, unfortunately. So we've downsized to me. I am Waterview Title Services right now. It had been in my prior speech, it was me and my father. Lack and Lack Chartered is me and my father in practice together. And we've been doing this for a little over 30 years together. Dad has been doing it over 60 years, but unfortunately, COVID sent my father into retirement. He's 85 years old, so he's certainly entitled to be retired. I was hoping to keep him working forever, but COVID had other plans. Thankfully and happily, he's healthy and fine. It is not an illness thing. It's just he couldn't come into work, and when he stopped coming in, he said, all right, this is pretty good, I'm done. So now Lack and Lack Chartered is just me, and then through one spin or another, Waterview Title became just me. I am contemplating hiring, so if you know any good, competent title processors, feel free to give them my name and card, and I would be happy to interview them. But as it stands now, again, I am Waterview Title. I do provide full service. The advantage to using my office is I know what I'm doing, and I know it really well. So if there's a problem with the closing, I know how to fix the problem, and I know how to avoid problems. So I can see them coming and stop them before they happen and make sure we have a closing. All of us are in the same business to get to the closing table, and Waterview Title Services knows how to make that happen. So again, thank you for attending the seminar and welcome, and I will turn it back over to John. Well, thank you, John. I appreciate that. And thank you, Waterview Title, for doing such a good job in sponsoring our program. Okay. All right. With that silliness, but important silliness out of the way, I'm going to get started. The way this class goes, I've been doing this now, it's about 15 years. I started in 2006 when Scar asked me to come teach a class. And back then it was, I think it started at an hour, and then they bumped it up to an hour and a half. Then we bumped it up to 2 hours. It used to be part of your mandatory orientation when you joined SCAR, which I thought was a wonderful thing. And that's how it went from 06 to about 2010. In 2010, they changed the contract from a 4-page legal size document front and back to the 10 or 12 page document, 12 pages that we are dealing with now. And because my contract classes always went long at an hour, then an hour and a half, then 2 hours, they decided they couldn't squeeze this 12-page contract into the time allotted for the orientation. So they removed it from the program. Took about a 2-year hiatus, and in about 2012, I started teaching it again just as a standalone class. Then a couple of years after that, I said, let's get it accredited. So now we bumped it up to 4 hours, lucky you. Now there's pretty much enough time for me to get through the contract. I say pretty much because I tend to run long even with 4 hours, but I'll do my best to make sure we're done on time. But now you get credits for this too, so at least you're getting something for sitting through it all. The way I run the class is I just go top down. I mean, I'm not going to read the contract to you, but we're going to go ahead and read the contract together. And what you see here is the contract with my little notes, and it is unscripted, and I do tend to fly off in tangents. So Some of you might have sat through this before. I like questions. It makes it more interesting to me to teach the same thing over and over. It's nice to have questions that make it different. So feel free to ask questions, but what I do ask, especially with the Zoom folks, which will be interesting for me, but we're going to do this in sections. So it's going to be parties and then property, then purchase price, et cetera. And we'll take questions at the end of each section. That way I get through the section. I might answer your question before you have to ask it. And if not, then we'll do it at the end of the section. If I find we're running long, then I'll do something about the questions. But again, please ask because it makes it more interesting for everyone. And quick history about me. Again, as I already told you, it's me and my father in practice, or now it's just me, but Dad, I still consult with him and I still see him regularly and throw questions at him, so I'm keeping him involved. We are a transactional real estate law firm, and by that I mean we primarily practice in transactional work. I do other spin-off work of when it's related to real estate. People need to form a corporation or a limited liability company, things like that. I do minimal estate planning. Otherwise, I refer that out to the bigger boys as far as estate planning goes. But if you have a simple will and such, I can do it. But my practice focuses on representing buyers and sellers in real estate transactions. I do both residential and commercial. The primary practice is residential, but I probably about 25% commercial. And again, I've been doing this a lot of years and know both sides of that table. What I've been up against my entire career as an attorney is realtors telling buyers and sellers that they don't need an attorney. Oh, the title company will take care of everything. You don't need to get an attorney. It's all very standard, et cetera, et cetera. And that's true to a large degree. When everything goes fine, you don't have to have an attorney in the state of Florida to conduct a real estate transaction. However, in some states, they do require attorneys, and even where they don't, you have people, especially in the Northeast, who want to have an attorney representing them. So my plea to you is don't tell them, no, you don't need an attorney. The title company will take care of everything. If you have a buyer coming from the North and they want an attorney, have them give me a call. I assure you, my job is the same as yours. It's to represent them, to get them to the table. I know there's a reputation of attorneys out there that they're going to queer the deal, or they're going to make things harder than it needs to be, or they're going to cause trouble. Now, it is true that as an attorney, I represent the buyer or the seller. So yes, everything I do is going to be for the benefit of my client, the buyer or the seller. Unlike realtors who have the option, again, not that you all do it, but you have the option of being a transactional broker, wherein you represent the transaction and you have duties, which we can discuss a little bit here when we get to it, but you have duties of loyalty if you're a single agent, or honesty and fairness, but you're not necessarily representing one side, whereas an attorney, that's what I'll do. So sometimes it might look like, oh yeah, he's causing trouble because I'm pushing for my side. But my client usually either wants to buy the property, and I'm going to do everything I can to help them buy it, or they want to sell the property, and I'm going to do everything I can to help them sell it. I may try to twist it to be in their favor, but I will always be trying to get to the end game of getting my client to buy or sell their property. So it's not my job to cause trouble in a deal. It's my job to make sure the deals happen. So again, I implore you, if your buyers or sellers are wanting an attorney, feel free to have them give me a call. I promise not to kill the deal unless, and here's the unless, of course, they want me to. I'm often hired to get somebody out of a deal. So if I'm hired to get somebody out of the deal, yep, you're going to hate me because my job is to kill the deal, but that's what I was hired to do. And I'm sorry, it's nothing against you. My client says, John, I need out and I can't afford to lose my deposit. Or my client says, I've decided I don't want to sell the property and I don't want to be sued for specific performance. Or John, the buyer bailed out and I want to keep their deposit. So when I get hired for those matters, then again, I look like the bad guy, and sorry about that, but it's because the client didn't want the property or whatnot. So with that said, the purpose of this class is to learn how to prepare this contract so that when I come along as the bad guy trying to get out of it, I have no leverage. If you do your job right and we fill this out properly, then if somebody breaches the contract, then they're going to either lose their deposit or be forced to sell it or whatever the case may be. Versus if you leave me a loophole, and I will point out those loopholes as we go through this, you give me an opportunity to get my client out of the contract, you're going to look bad because they're going to say, well, how did he do that? And the answer will be, maybe you didn't check the right box in the contract. So again, my job here is to help educate you so you understand what the pitfalls are and you know how to close loopholes so that you don't end up in a problem. And then the last, not the last, I will jump around like I'm doing now, so it won't be the last time I jump off, but couple of different things. The preparation of the contract is the practice of law. So when you guys are preparing contract, you are committing the unlicensed practice of law, unless any of you are licensed, in which case it's a third-degree felony and I'll see you all in court. But no, the good news is the state of Florida, or the Florida Bar and the Florida Association of Realtors got together and said, we need realtors to be able to prepare contracts. So even though preparation is the licensed practice of law, is the practice of law, and if you're unlicensed, it's bad, the realtors in the Florida Bar, so they created what is called the FAR Bar. It's a collaborative effort on this contract, and it applies to others as well, but this is the one we'll be going over, is you're authorized to fill in the blanks. They've created a form of contract that you are authorized to use, and you're filling in the blanks of a contract. So you're not drafting legalese, you're not creating a contract, you are making some very significant choices. And again, that's why you're here, for me to explain that to you. But you're filling in the contract, and so it is an exclusion of the unlicensed practice of law. But it's very important, and I'll get to this way later when we get to paragraph 20, which is 4 hours from now. But when we get to additional terms, when we get to other things that you might need to put into the contract that's not there, be very careful not to draft legalese. And again, I'll get to that later. But you should, especially those of you who know, I forgot this part, and sorry, Zoomers, I don't have the skills to look down and up at the same time, but how many of you are new to the business, as in less than 2 years? Okay, so it's a decent amount, which is what I would expect. And how many of you have been doing this for, say, 3 to 5 years? Okay, over 5? There you go. Okay, so we got some experienced folks. I won't even go over 10 or over 20, but I lost my train of thought there. Sorry about that. So what I was getting at is, get to know a real estate attorney, not a divorce attorney, not a criminal attorney, not a friend's brother's, uncle's, cousin's, sister's, nephew who had just passed the bar. Get to know an attorney who practices in transactional real estate, who can help you through both the transaction you might be having trouble with now and somebody you can call on in the future. I'm happy to be that person. I try to be a resource to the local realtors. You're always welcome to call me. You're always welcome to ask questions. I'll do my best to answer them for you guys. And then if your clients need to call, I'll either answer. I'll always give a phone conference. I don't quote free consultation, but I usually end up with a free telephone call to make sure I can help somebody. And if I can help them, then I'll charge them for my services, or sometimes they end up with some good free advice and they don't need my help because I was able to help them through those single question. So again, find somebody like me that you can call upon when you have questions, especially as we get to paragraph 20. So I know there will be other jump offs because that's what happens every time I do this. But before I get started, are there any questions? Okay, great. Then we are going to get started on the yes, ma'am.
Just one question.
Sure.
About when you were talking about contracts. We're not the only ones that write contracts. If you go to a car dealership, they have contracts.
Yeah, and they have, if you're talking of the unlicensed practice of law piece of my conversation. So for those on Zoom, she was just making the comment that I had said the realtors in the bar got together and dealt with the unlicensed practice of law by having a form of contract. And she was pointing out that there are other entities like car dealerships and stuff who do similar things, and they have similar carve-outs for that. Again, you won't find a car dealer handwriting a contract from scratch. They're taking a form of contract and filling in the blanks. So again, we're not the only industry that has created this allowance to prepare contracts, because you're not literally drafting it, you're just filling in a pre-prepared, pre-approved contract that some attorney has drafted somewhere in the past. Does that cover that? You're welcome. Okay, so we are going to get started. If I can figure out, oops, I think I have to move the mouse to here to make that live, to go like that. There we go. Okay, so interestingly, yesterday, coincidentally, I was cleaning off my desk. I'm not sure what this is from. Oh, it's July, so this is current. Okay, another quick backstory. I told you this would happen. So for full disclosure, again, I'm a transactional real estate attorney. I've been doing it for over 30 years now, which boggles my mind, but it is what it is. And I've been a title, which again, me and my father in practice, and dad had a title company that he formed in 1979. I joined the firm in 87 and have been doing that, so 34 years now as a title guy. And then I got my law license, bar, and have moved on. In 2012, I actually became a realtor such as you guys. And then in 2014, I became a broker. So I am a licensed real estate broker. I am not really practicing. I am not really competing with you. I'm not out there trying to steal your clients and do the business that you're doing. I'm here to help you. That said, every so often a nice sweet deal drops into my lap. And as a real estate agent, I do handle those transactions. So if you happen to see my name, or if we happen to be on opposite sides of a real estate transaction, it's not that I was out there trying to get business that you're trying to get. It's because some prior client of mine has come back and said, John, I want you to handle this. So, but as a result, and it was a major shift in my brain in 2012. I told you I was teaching this class since from 06 and been dealing with realtors since 1987. And my opinion of the work you did and my opinion of the nature of the business changed drastically when I stepped onto the other side of the table and became one of you and started dealing with what you guys are dealing with. I sit in an office, I deal with paper, I'm on the phone a lot, I do a lot of, client contact, but I never left the office, I never saw the houses, I never went to inspections, things like that. So when I became a realtor, I realized you guys do a lot. There's a lot involved in being a good, competent realtor, and the contract is an important piece of it. Obviously, that's what we're trying to get to, is selling a property. But I, again, respect out there for all of you doing all the hard work. And I do now, having stepped onto your side of the table, understand that. So I can also give advice as to how things go in that regard as well. And so now I can actually raise my hand at over 5 years, which is also shocking, but there you have it. So in any event, where that spun come from, I do get Florida Realtors magazine, and I skim through it, and I noticed in the July issue, there's Nail the Contract. So Zoomers, I don't know if you can see that, but this is right out of, the Florida Realtors magazine, and it's a very short, I'm gonna go 4 hours, and they went 2 pages, but it had some good things. It's basically telling you to be careful, and it's basically telling you, things aren't always as they seem. So very short, sweet article, but I do recommend, you take the 5 minutes to read it, but hopefully this class will give you much more in the long run. And one of the things it pointed out, which I thought was funny, because I don't think anybody's using paper anymore, but I noticed back in the day, I don't know if I brought it with me, but I found one of Dad's, I guess, in a drawer, but a 1978 version of the FAR bar contract, the 2-page legal size version. And I carry that with me, but it's the same thing, just they keep adding stuff to it. There's asterisks next to some of the line numbers. And back in the day when I had a legal pad of these, I was like, what's this darn asterisk? Why are they marked? And the asterisk just means that there's a blank on that line. And this article tells you the same thing. So I thought that was kind of funny. But if you see an asterisk, it means there's some blank to attend to. Now, again, we're all using computers now, so you're probably tabbing to the blanks, and you don't really have to look at asterisks, but that's what that means if you ever wonder. All right, now we're finally getting to it. And where are we on time? Okay, a little bit longer on the intro than usual. I'll try to keep the ball rolling here. So as I say, as far as questions go, I'm going to talk through this page and then we'll take questions in the next page, etc. So not always one page at a time, but so diving right in, parties. It does seem like a very simple thing. You have your buyer and your seller, but of course nothing's ever that easy. So I'm going to start with the seller because that's how the slide looks. The seller is the owner of record. Now, I've seen realtors put owner of record. That's not acceptable. You can't put owner of record at the line that says seller. You can, in theory. It wouldn't mean it's not a binding contract, but that owner of record has to sign it when we get to the signature page. So you obviously know who it is because somebody is signing their name. Put their name on the line. Don't put owner of record and then have somebody try to read the signature, because I've tried to do that and it's not easy. You couldn't read mine. So the owner of record. So again, I go back a long ways, not, well, I do go back before the internet, but besides that, as far as contract preparation in this class goes in '06, not everybody was quite as computer savvy as they are now. Is it safe to say you're all familiar with the Brevard County Property Appraiser site, or whatever county you're working in, the Property Appraiser site? Great. Are you familiar with the clerk of the court site, official records and such? Okay, good. And then the last one is the tax collector, to check to see if the taxes have been paid, et cetera. Those are what I call the big three. The property appraiser, the tax collector, and the clerk of the court are the three constitutional officers that do their various jobs. And so I call it the big three. Whenever I open a file, I mean pull the property appraiser, pull the tax collector, and here's the important part, pull the last deed of record. So the last deed of record is through the clerk of the courts. I do teach a class on title examination, and I will explain it more in that class, but in this class, I will tell you the easiest way to get to the last deed of record, and again, it's not legally binding, but it is effectively accurate, is to go to the property appraiser site. I keep saying Brevard County, but if any of you are practicing in other counties, the same applies. So you go to the property appraiser site. In Brevard County and most counties, about halfway down, 3/4 of the way down, they have what I call a mini chain of title. They show you the last deeds of records, and there's usually more than one, but the topmost one is usually the most recent deed. And you can usually, in most counties, in Brevard especially, you can click on the book and page number and it will bring you to the deed, to the clerk of court page, but it'll actually bring you to the deed. That's what you want to rely on for the owner of record. Now, provisos to that. There might be a quitclaim deed where we're adding somebody to the title, so the deed might only be a partial interest. It might be taking someone off. There's a variety of times when the last deed of record might not actually tell you all of the parties, because again, it could be partial interest or things like that. So the things to look for, your standard deed and the standard transaction you guys are gonna be doing is a warranty deed. That's what most people, when they sell a property to an unrelated third party, they do a warranty deed. A quitclaim deed is still a valid conveyance of title, and you can do a quitclaim deed the same as a warranty deed, but it's usually done when you're transferring property either to an LLC or to a trust or to a family member or something like that. If you see that it's a quitclaim deed, maybe look at the deed before that just to make sure that it's a whole interest, and it probably will be, but again, it never hurts to go back one or two deeds and look at what I call the mini chain of title to make sure that you're dealing with the current owner of record and all of them. Now, as far as the seller owner of record, how their name is spelled on the deed as the grantee. The grantor is the seller, the grantee is the buyer. On the deed, of course, the grantee, the buyer, is your seller on our contract. So I got to be careful how I say that. So the grantee on the deed is your owner of record. How their name is spelled on the deed is how it should be on here. If they use the middle initial, put the middle initial. If they didn't, they didn't. Now, another one of my standard remarks in my office, it's gospel. Out here, I suggest the same. If you see a discrepancy, address the discrepancy. Don't ignore it. Don't say, oh, whatever, somebody else will catch that later or something. If you see something, deal with it. Whatever the dealing with it is, again, in the end, dealing with it might be not worrying about it, but what I hate more than anything is sitting at a closing table and I say, oh, look, your name is John Jon, not John John. And, you know, oh, the contract said JOHN, all of my documents have JOHN, what's going on here? And then the realtor said, yeah, I noticed that. I just figured it would get fixed. And I'm like, so our whole package is wrong. Everything has to be changed. And they knew about it. Somebody knew about it. Again, it's happened in my office where one of my assistants will say something like, I knew about it. I'm like, you know, so if you see a discrepancy, raise the discrepancy. If there's a problem on a deed, it's kind of a bummer if the deed is wrong, but so be it. We can fix it. If I know about it, I can do an AKA, I can make it work. It's not a problem. But if I get to the table and it's all wrong, now it's kind of a problem. So again, if you see a discrepancy, raise it. Owner of record, the name as spelled on the deed. And you need, for a binding contract, again, that's in here as well. For a binding contract, you need all of the owners of record to sign. So if John, Joe, and Jane own the property and only John and Joe sign the contract, and you get to the table and Jane says, I'm not selling my property, they might be able to sue John and Joe, you know, because they signed a contract and they offered to sell the property and they don't own it and there's warranties, but Jane doesn't have to sign it if she didn't sign the contract, and your deal could die at the table, even though you might have a good lawsuit later. So my job, again, another one of my tangents, is never to end up in court. Never to, I don't do court work. I'm a transactional guy. It's not that I've never done court. I try to avoid it desperately. I will represent a client through court if we end up in a fight, but my goal is not to get there by doing everything right up front. What I tell clients is if you're in what you need to imagine is that you're standing in front of the judge. Here I am at the lectern, and there's the judge there, and I'm telling my story. And am I on the side of right or am I on the side of wrong? I always tell a client, I'd rather be you or I'd rather be the other side, sorry, whatever the case may be. Even when I'm sure I'm right, judges can have a bad day and they can rule against you. It is amazing how often you have a judge who rules one way and appellate court rules another, and then sometimes the Supreme Court overturns one or supports it. So it's not ever as cut and dry as you might think it is. And your goal is never to be standing in front of a judge. If you are, and you hope you're doing it because you're on the side of right. But again, know that a judge might see it differently and try to avoid that situation. So that would be, I brought that up because of Jane not signing the contract. I don't know why it came up then. So in any event, the next note on seller is marital status or non-homestead. So quick homestead lecture. In the state of Florida, the Florida Constitution provides that no person may convey or mortgage homestead property without the joinder of their spouse. It's right in the Florida Constitution. You cannot convey, which is sell or deed, and you cannot mortgage, which is borrowing money against and secured by, homestead property without the joinder of the spouse. It comes out of an 1896 revision to the Florida Constitution because back then women couldn't own property. So all of you women out there back in 1896, you couldn't own property, and men were scoundrels. We probably still are, but men were scoundrels, and they would gamble away houses. And, oh, you know, we're sitting there at our poker game and throwing the deed because we're sure we're going to win. And then we lose and we just lost our house, and the family gets booted out of the house. So society, Florida society anyway, said this is bad. We can't let men go ahead and do that. The women, the spouses, have to be allowed to join in the deed. Well, fast forward to 1968 and now women can own property. Yay. Yeah, it's crazy, isn't it? Now freewheelers, which I don't even know what that means, but I know that was the term, women could own property, but I don't really, again, that predates me. So I don't know all the details there. But now you get to own property, and now spouses doesn't necessarily mean husband or wife. You can have same-sex marriage now. So we use the term spouse, and you cannot sell or convey your homestead without the joinder of your spouse. You can own it. I can own the property in my name alone. And that's fine. It's my property, and I might have bought it before I got married, or me and my wife decided to buy it, but we decided to put it in my name alone. Whatever the reason, I can own property on my own. But if I go to sell it and it's homestead property, meaning your primary principal residence or that of your dependent family member, then I can't sell it or I can't mortgage it. Why is this important? You don't have to put this on the contract. So this is one of my little side lectures that's important for the transaction. If you put it on the contract, I'll have comments in a moment. But when you get to the table, if your seller shows up and the contract just read John Lack and the title company just saw John Lack and John Lack was the only one in title, and then I'm sitting there across from me, so that's weird, and I see the wedding ring and I'm a curious guy, oh, I see your wedding ring. When were you married? Oh yeah, we've been happily married for 30 years. I'm like, where's your spouse? Oh, she's off in Jamaica. We're going on vacation as soon as I get the money from this house. Oh, did you guys live in this house? Yes. Oh, guess what? You're not going off to Jamaica because we need your wife to join in on the deed. You can't sell the property without the joinder of your spouse. Same story for the buyer. If the buyer, John Lack, is buying the property in my name alone, but I'm getting a mortgage and I'm buying it for my family to live in, my spouse has to join on the mortgage as well. Doesn't make her a debtor, doesn't mean she owes any money, but she has to consent to the property being used as security for the transaction. So again, it's not so much for contract preparation, but it is for you guys to be aware, if it's homestead property, the spouse doesn't have to join in the contract, but the spouse is gonna have to be at the table to sign either the deed or the mortgage, depending on which side we're talking about. So if you know the information, you know John Lack a single man, or you know he's a married man, then it doesn't hurt to put it. It is bad to put misinformation, and it is bad to guess. So if you don't know, leave it blank. The title company will hopefully inquire and get the answers before closing, and we won't have those situations with me at the table noticing a wedding ring. But if you do know it, it's okay to put. Likewise, again, sometimes you'll have a father and a daughter buying title together, property together, and she's not married. So if it reads John Lack and I don't have a daughter, so Donna Lack is my wife, but we're going to call her my daughter for a moment. And it reads that, and you assume, you know, as a title company, I see John and Donna Lack, oh, they're a happily married couple. And it turns out it's father and daughter. I've seen, again, on the other side of the table, not from my office, but I have seen, you know, fathers and daughters end up married, father and daughter, husband and wife, you know, that's not good. So, so again, if you know the facts, the contract is all about getting the facts on paper so that there's no issues, so that we have a nice, smooth closing. So the more accurate information you put on the contract, the better it is. And the stories I'm telling you are the reasons why it's important. But again, it has to be accurate information. So that's the punchline to that. Now we move on to the, so we're done with the seller. Any questions on seller? Oh. Yeah, you can put, yeah. So the question for the Zoomers was, if it is a father and daughter, how do you put it? Again, you could put John, a married man, you know, you could put in parentheses father, and then daughter, or it doesn't matter. And again, I should be more prepared to answer that question, but the truth is it doesn't really matter how you put it. They're still just going to sign their name on the contract. And actually, as I'm talking, I'm also envisioning me typing up a contract. And nowadays, in a lot of the programs you use to type the contract, they don't give you as much flexibility in the space you have anyway. So it might be one of those where just make a note of it. And I'm going to get to the buyer side that'll have some relevance to this. So again, put as much information as you and your computer will allow you to put. Make sure the information is accurate. But then, as importantly, make sure you're communicating with your clients and or the title company so that it doesn't end up, I prepare the deed and I put father and daughter as husband and wife. Even if the contract just has the names, you can shoot me an email, hey, this is a father and daughter buying the property. And then I know, again, so a lot of this is about communication in addition to the preparation of the contract. You have a question?
Yes, I'm understanding that if the property is a homestead property, the spouse have to sign the contract, they just don't have to be on the deed, is that correct?
Okay, so the question was, if it is homestead property, do both spouses have to sign the contract? The answer is no, they don't have to. Only the owner, if we're talking about a seller, only the owner has to sign the contract. However, the spouse does have to sign the deed. So it doesn't hurt to have the proper phrase, or I don't know, it is become legalese, whether it is in courts or not, I don't know, but it's certainly become the practice to use the phrase joined by. So it would be John joined by Donna. And the joined by is the legalese that says she's joining in for homestead purposes, not John and Donna. The and meaning she is also a part of the contract, and all of the warranties of title are in the contract apply to the and. If you put joined by, there's some understanding. Again, I don't want to say it as a pure legal advice because I haven't done legal research on it, but I can tell you from years of practice, when we put joined by, my immediate interpretation is they're joining for homestead purposes, but not attending to the warranties. So again, I don't usually have the non-owner spouse sign the contract, but I do make sure that the non-owner spouse is aware that they have to be at the table to sign the deed. And I don't think, it's not in this contract anymore. I know South Florida had their own version of a contract that actually had a provision in it that the seller, if the seller was married, one of the obligations specifically in the contract was that the spouse would be at the table to sign. But I believe that's kind of inherent in the warranties of title anyway. They just were explicit about it. So again, I'm being explicit in my explanation, but from a contract preparation standpoint, it is still just the owner of record. The spouse does not need to sign the contract, but they will need to sign the documents. So now we get to buyer. I'm only through to buyer. Oh, yes, sir.
Father and daughter property, but daughter is married, right?
Okay.
And the property, can the property be homesteaded?
Okay.
Going forward, the spouse of the daughter has to be present for the property?
If it's a sale, the spouse has to be present to sell, and if it's a purchase, the spouse has to be present to join in on the mortgage. So the question again for the Zoom is, we discussed the father and daughter situation, and daughter turns out to be married and it's going to be homestead property. So we're buying it in father and daughter's name, but its daughter is married. And does daughter spouse have to join? And again, not on the contract, but on the deed if the daughter is a seller, and on the mortgage if the daughter is a buyer. So anytime you're dealing with homestead property and a spouse exists, the spouse will have to join in the conveyance, the deed, or the mortgage of the property. Every single time. There are no exclusions. There are no exemptions. There's a tiny little loophole for prenuptial agreements, but even then title companies are going to want the spouse to join to waive their interest anyway. So punchline, if they're married, make sure the spouse, and it's homestead property. The alternative is it's not homestead property. If I'm buying a rental property, then I can be married and the spouse has nothing to do with it. So again, this is only homestead, but a lot of what we deal with is homestead. All right, let's dive into buyers. I'm taking a little too long on this page, but I'll make it up elsewhere. The buyer, again, this to me is very important, and I try to be very careful with it, and it doesn't always work. But ask the buyer how they sign their name. I'm Jonathan D. Lack. I use my middle initial. And when I go to sign mortgage documents for a loan, I'm going to be signing my name 100 times. And I want to sign my signature, Jonathan D. Lack. The banks are very particular. I have a ongoing feud with banks about this issue, but the banks are very particular that you must sign your name as written. Well, if it's written Jonathan Lack without the D, then they don't want me putting my D in, even though that's part of my signature. So what I tell clients who have this problem on the other side of the table, if your signature is one of those illegible lines, then I tell the bank, that's what it says. Whatever we want it to say is what it says, because it's illegible. But if you have one of those nice, neat, legible signatures, then you can't pretend the D is not there when there's a big D in the middle of your signature. So I like to do the contract the way my buyer signs their name. Now, the provisos to that, if you have a very common name, then I recommend at least you, even though you don't, let's say it's John Smith, no offense to any John Smiths, but if you're John Smith and your middle name is Zachary, either put John Z. Smith or better yet, John Zachary Smith, and it's going to distinguish you from the other John Smiths. When we run title, again, I'm running long, so I don't have time for this piece, but when we run title, we do a name search. And If I do a name search of John Smith and I have 1,000 different John Smiths to make sure that there are no judgments, liens, et cetera, it's a lot of work. If it's John Zachary Smith, I just eliminated all but the John and John Z's. I still have to look at all the Johns, but I don't have to look at the John R's and the John S's because I know I'm John Z. So again, you assist common name parties by using their at least middle initial or full middle name when the case may be. And yep, they're gonna have to sign Zachary every time and they might not remember how to do it. And I'll have to sit there, don't forget your name, don't forget your name. But it's in that scenario, it's better. But otherwise, if they've already pre-applied for a loan and they've already, you can ask them, how did you tell the bank? And if they said, I just said John Smith, you can do it that way. Again, the bank's gonna plug it all in one way. They're gonna send it to the title company. The contract's gonna be one way. If there's a discrepancy, and there are a lot of times there's a discrepancy, I try to reach out to the bank. I try to reach out to the parties. I try to make my title commitment match what the parties want. But the ideal from my perspective is that it matches the contract. And it doesn't have to match the driver's license because the driver's license, for example, mine says Jonathan Douglas Lack, and it puts your full name. And I think for ladies, sometimes it puts married name as the middle name. Sometimes, it does a variety of, the driver's license bureau does things that might not be how you sign. So again, if your license reads somehow differently, we're going to need an affidavit that you're you, maybe. But if I hand somebody my license that says Jonathan Douglas Lack and I'm signing Jonathan D. Lack, it's not going to be a problem. Again, if it had some other name on there, then it would be, again, that happens in marriage situations or whatnot. But so no, it doesn't have to specifically match the driver's license as long as the name is obviously the same in some fashion. So I don't have a lot of time to deal with the multiple owners because we've taken a little long on the front end, but real quickly, those initials mean tenants in common. All right, I have to do it. I can't stop myself. So there are multiple ways 2 or more parties can own a property together. I'm going to keep it at 2 right now. So you have 2 people buying a property together. If it's a husband and wife, the default is tenants by the entireties, and that's the third one there, TE, tenants by the entireties. Tenants by the entireties treats a marital relationship, and again, be husband and wife, it can be husband and wife and wife. But in any event, it treats the marital relationship as an entirety, as one. And it has a right of survivorship. So if one spouse dies, the other still owns it, et cetera. But it treats them as one and it offers some other protections. I won't get into that now, but that's the default when it's husband and wife. But if it's me and my brother want to buy a property together, so John and Jeff, and we decide to invest and buy a property together, we can own it either as tenants in common, which is the default. If we say nothing, if I say deed to John and Jeff, then that's tenants in common. If I die, my estate has to be probated and my share goes to my heirs, whoever they may be, whether it's my spouse, my kids, maybe it is my brother anyway, but my share goes to my heirs and Jeff's share goes to his heirs. Joint tenants with right of survivorship means if I die, Jeff automatically gets my interest, and if he dies, I automatically get his interest. And there is no probate of our estate. The death of one automatically causes the right of survivorship to transfer to the other. And all you do is record a death certificate to evidence that. So very significant difference between tenants in common going to heirs and right of survivorship. If as a title company, I see names and I know it's not husband and wife, it's very important that I know it. I'm not suggesting you guys have this legal conversation with your clients other than to mention it to them. Have them call me, have them call the title company, but the title company needs to know how to prepare the deed. And I see it all the time on the negative side of things. Somebody dies, the other assumed there was a right of survivorship, there wasn't. Now we have to probate an estate instead of this party getting it. And sometimes the party ends up with it anyway, all is well other than the probate cost. Other times it's going to estranged heirs, and now I own the property with people I don't even know, and that's bad. So it is very significant if your intent is to have joint tenants with right of survivorship, it has to be explicitly stated on the deed. Again, this is not a contractual matter. I'm just pointing it out. Again, I want you to understand how to get to closings, not have problems at closings, and especially not have a problem after the closing if somebody passes away and it was wrong. Again, you're not bound to the legality of it, but be aware of it so you can help advise your clients, which will help you get more business in the future. All right, I took a lot longer on that than I intended, so I'm going to try to pick up the pace, but I will say any questions there. Good. All right. We are on to property description. Okay, so we're going to go A, B, C, D, E. So A is really easy, the street address. That's the address of the property. Ooh, really hard. Please put the zip code. There's a lot of zip codes, and even Palm Bay has 4 different ones, and Melbourne has 2 or 3 different ones, and then some overlap where it could be Melbourne. I'm doing one now where it's in a little pocket. We think it's in the Atlantic, but it's really not. It's really the city of Melbourne because there's a pocket of Melbourne in the Atlantic. So again, if you put Melbourne, Florida, I would never have assumed 32903, which is in the Atlantic, but in this case it is. So please put the zip code. Now, for contractual purposes, the street address is solely for the post office. It is not the controlling factor of your sale. It can be used as evidence if you make a mistake on C, which I'll get to in a moment, but the controlling factor is C, the legal description of the property. So A, the street address, is really just so that we can send people mail, so we can send them notice. It is, however, legally required to be on a deed. In order to record a deed, you have to have an address for the parties. So we do need an address of the property. That's not of the parties, I guess, that's of the property. But it is important that you put the street address with the zip code. Now, the B is very easy. Property is located in blank county. Brevard, Orange, Indian River, wherever you're doing business, fill in the county. Real property tax ID, another one of those annoyingly simple that's not. In Brevard County, we have tax account numbers and parcel ID numbers, and they are different. Many counties just use the parcel ID number as the tax ID number. So for most of the state, tax ID number and real property ID number are the same. But when it reads real property tax ID, in Brevard County, that's 2 different numbers. Doesn't matter which you put. It's important that you put either the tax account number or the property ID, but which one you put isn't going to matter. What does matter is that you put a correct one, A, and B, sometimes there's 2. This is very important. If there are 2, if you're selling a multi-parcel lot that might only have 1 house on it, it might have been 2 lots combined and they built a house in the middle. And I'll get to that when I get to C as to other pitfalls. But there's the possibility that there are 2 tax ID numbers. So make sure if there's any, again, remember I talked about discrepancies. If you see a discrepancy, if you walk up to a property and it looks like a double lot and you think it's only 1, ask them, hey, by the way, this looks like a double lot. Do you have 2 tax bills or 1? Oh yeah, I'm glad you asked. I get a tax bill on that other one, but it's only a few $100 a year. Yeah, it's only a few $100 a year, but if you don't tell us about it, we don't transfer it, then 5 years down the road, you stop paying it because you sold it. The new people didn't know they bought it because it wasn't here and it didn't get on the deed and therefore it didn't get transferred. And then your little vacant lot got sold for a tax deed and you have a big ugly problem. Again, everything I tell you comes from some form of live anecdote. So these little silly stories all have happened. Not because of me, I've heard of them after the fact. Not to say that I've never made a mistake, but yes, ma'am.
I'm going to set a and that is so important. Buyer, when it
Right. All right, so she was just pointing out that, again, this is for the Zoom folks. So the statement in the audience was she's handling a transaction with 2 lots, and for the buyer to be able to obtain homestead, they're gonna have to combine the lots. The proper term there is called a unity of title, and you put the 2 lots together as one, and then thereafter, even though it's lots 1 and 2 of Happy Acres, it's deemed one property, one parcel, whereas in the beginning it could have been 2 different parcels. So again, very good point and very important to know for homestead purposes, you may have to do a unity of title to get homestead on the whole of the 2 lots. So as far as, again, contract preparation goes, whether you put the Brevard County property appraiser's parcel ID number or the tax collector's tax account number, I don't care and it's legally binding and it won't matter is A, long as it's accurate, and B, if there's more than one, make sure you put it. Now we get to C in my little standard lecture on legal descriptions. And one of the things I love about real estate and is the spot we're standing on here is fixed. It's not going anywhere. Barring the earth going somewhere, the land is going to stay. So I'm just going to stick to the state of Florida for now. The state of Florida has legally described every inch of the state of Florida, and you can identify it via what's called a legal description. And you can search the ownership of every piece of land in the state of Florida all the way back to when the Queen of Spain ceded it to the United States in 1827, and then the United States created the state of Florida in 1845. We can tell you every person who's owned the exact spot I'm standing on from the Queen to now. I assume it's the Space Coast Association of Realtors, though I haven't looked that up in a while. I did look it up a few years ago and it was, so there you go. But in any event, we can search every parcel of land, and it's done via the legal description. Now, a messy legal description, what we call a meets and bounds legal description, is where you literally draw it out, and that's a surveyor is the one who does it. But what's meets and bounds, it's distance and measures, or measures and points or whatnot. I forget the verbiage here, but I'm going to give you an example. So we're going to start at the American flag, and we are going to go north 100 feet to the chalkboard or whiteboard, and then we are going to go west 75 feet to the light switch on the wall. Then we are going to go south 100 feet to the exit sign. Actually, that's about 125 feet to the exit sign. And then we're going to go from the exit side at an angle of 72 degrees, I'm making that up, back to the American flag to the point of beginning. And we've just kind of drawn out, not the room actually, because I cut the corner here, so where I'm standing wasn't described. But in any event, that's a meets and bounds legal description. When you come up against that, when you pull the last deed of record, where you should get the legal description is from the deed. The seller only owns what they own, and what they own is what they bought on the last deed of record. So if there's a mistake, remember what I said, if there's a discrepancy, address it. Make sure we know, hey, wait a minute, something's wrong here. But you're not going to likely see that in the meets and bounds legal. But if you have a meets and bounds legal description, it is okay to put under, instead of typing all that long thing out, you can put as per deed recorded in official records book 1, 2, 3, 4, 5 at page 678, public records of Brevard County, Florida. And you could shorten that a little too. But the point is you can do legal description by reference. If it's reference to a recorded document, that's a legally binding reference. So you can do that instead of typing the whole thing out. Or you can do an attachment, or you can attach the deed, or any which way you want to get the legal description. But the legal description is what you are selling, not the street address. Again, so if there's a discrepancy with the address, point it out and let's figure it out. But the legal description is what you're selling. The good news is developers came along, especially in the residential world, and platted subdivisions. So the developer came through and just took that meets and bounds legal of this room that I just described, and they made it into a subdivision. And they made each of the tables a block rather, and each chair is a lot. And they put in streets, which is the walkways between you, and they put some easements for trash in the corner and things like that. And they made a platted subdivision. They submitted to the county accepted it, and then voila, that is lot 1, block 1 of the SCAR subdivision, according to the plat thereof, recorded in Plat Book 2, page 10 of the Public Records of Brevard County, Florida. So that's lot 1, block 1, that's lot 1, block 2. She's sitting in lot 3, block 3, and forever after, that's the legal description. Now you can abbreviate it when you're on the property appraiser's site, which is what a lot of realtors do, and it ports in from the when you're doing it on one of those programs, Flex or whatnot, might port it in. They have abbreviated legal descriptions. They will almost always be okay in the residential world. Lot 1, block 1, happy acre subdivision. That's fine. You're good with that. But sometimes if it's multiple lots or it's a meets and bounds legal, it'll have, either et al. Or it'll ... or something. So don't assume without looking that what they have is accurate. Look at the deed. The deed is what controls, and the deed is what should go in the legal. Again, I don't have a lot of time for my other little spin-off of multiple properties. We kind of touched on it before, but if you see lot 1 and lot 2 you know, when you pull up the deed, it's important that you know, are we selling both lots? I might have bought two lots together. I built a house on one. I have a vacant lot on the other. I need some money, so I'm selling my vacant lot. So I come to you and say, sell my vacant lot, and you do, and we get an offer, and the buyer's agent who prepares the contract pulls the last deed of record the way I told you to, good for you. And the last deed of record said lots 1 and 2 of Happy Acres. So they type lots 1 and 2 of Happy Acres. Well, I'm only selling lot 2. My house is on lot 1 and I'm selling lot 2 for $5,000. If we let it all go through and it gets to the title company and I prepare the deed and you sign the deed, you might have just sold your house along with the lot for $5,000. The opposite can also be true. Your goal is to sell both, but I bought lot 1 and then I subsequently bought lot 2, and then I either built a house on lot 1 or maybe I built it in the middle, but I didn't do the unity of title thing. So I have 2 separate deeds, but I'm selling them both. Again, it's important. There's a lot of weird little twists. Everything doesn't fit into a box. It's what makes it interesting, but it's also where the pitfalls come in. So make sure, again, when you walk out to this lot or the property to sell it and it looks like an oversized lot and you pulled the last deed and it just says lot 1, say, hey, you know, oh yeah, actually we have lots 1 and 2, you know. So be aware of your surroundings and inquire when something raises a question, because what you put on the contract is what the seller is selling. And if they don't own it, they could be sued for having agreed to sell something they can't sell. And if they after the fact say, wait a minute, I didn't intend that, then again, if it's an obvious mistake, it probably won't be a problem. But if you had an aggressive buyer who wanted to hire an attorney and say he signed the contract, you could have a problem. So again, accuracy counts, and there's that. Per deed. Okay, so then a couple of quick notes is line 12, together with existing improvements and fixtures. Now, I don't know who any of you were at there was an ethics class that I just took here, and I even told the guy after the fact, thank you. He gave a very good, it was the reasons realtors get sued. And I don't know if any of you took that class, but it was very good. And the best part for me was I learned fixtures. He had a whole segment on fixtures. And I don't have time to go through the whole segment on fixtures, but fixtures is one of those things. The way I said it, and I think he said it similarly, is if it's attached to the property in such a fashion that removal causes damage. That's kind of the definition I've always gone with. I don't remember if his was exactly that, but basically, if it's attached and my removal is going to cause some form of damage, then it's a fixture. So solar panels on the roof are probably fixtures. The question that comes up is a mounted TV a fixture? Yeah, you know, it's one of those, probably not. The mount might be a fixture, the TV maybe not, you know, I don't know. So again, I don't have a fixtures conversation, but when you sign the contract, you are signing it together with all existing improvements, which is the building and such, and fixtures, including built-in appliances, built-in furnishings, carpeting and flooring. So you don't get to tear up the carpet when you leave. I don't know anybody who would do that. But if you have a built-in entertainment center and it's, you know, it's built in, you don't get to remove it. I did have a case once where it was custom made wood, but it was not built in. Yes, it was secured at the top so it wouldn't tip over, but it looked like it was built in, and the sellers took it, and the buyers were very disappointed when they had a blank wall there instead of this beautiful wood entertainment center. And again, that was one of those fights at the table. I'll get to it in a moment on paragraph D. So table that for just a second. So, well, here we are on paragraph D. so it includes the existing improvements and fixtures, but then we get to personal property. So unless excluded in paragraph 1E, the next paragraph, the following items are included. So I'm an old school programmer. My undergraduate degree is actually math computer science, and I should have been a computer programmer, but I became a lawyer instead. So I still think like a computer programmer, and I use the term hard-coded. It's hard-coded into the contract that we will have a range: oven, refrigerators, dishwashers, disposal, ceiling fans, intercom light fixtures, etc. Right? So those things are automatically included. When you sign this contract, you've sold your refrigerator, your dishwasher, your disposal, your ceiling fans, all of those go, unless specifically excluded in paragraph 1E. So a couple of notes on that. Note there's an S after the word refrigerator. When you have a garage refrigerator, as well as the one in the house, if you sign this contract with no amendments, the garage refrigerator stays with the property. You don't get to take it and say, oh, no, I meant the other one. Well, you might have meant it, but your contract has an S there. So 2 refrigerators, you've sold them both. So if you want to exclude it, you need to put it on E. The ceiling fans, similarly, most people don't take them, but every once in a while you have something. The big one is light fixtures, and it's interesting, that's in this article. She used the same examples I've been using for 20 years, so I guess we're all the same here. You have your heirloom ceiling, your heirloom chandelier. So you don't, if you're gonna remove it, make sure it's on 1E, and I'm gonna get to 1E in a moment, but make sure you exclude it, because otherwise light fixtures, even though it's an heirloom, your heirloom chandelier is a light fixture, and you can't just take it if you sign the contract that it stays. So again, make sure you exclude those things. Now, the one that's not included, and the single most common item for a realtor to buy at closing is washers and dryers. They're not hard-coded in there. I don't know why, but somehow whoever prepared this contract decided that people like to keep their washers and dryers. And I guess it must be true. So if the buyer wants the washer and dryer, they need to specifically add it. If the seller is keeping the washer and dryer, they don't have to specifically exclude it because it's already not there. But again, realtors end up keeping deals alive by buying washers and dryers because the seller took it out on the walkthrough, it was gone, the buyer thought they were getting it, and to keep the deal alive, you buy your client a washer and dryer. So avoid that purchase, either negotiate it right up front, either it stays or it goes, but be clear on it. So then we get to E, which is the following items are excluded, and that would be where you would put the chandelier or the wall unit or anything that you're planning on taking. So here are my notes now. I'm actually looking down for a moment at my notes. Note, no washer and dryer. Now my old note says no microwave, but it does say ovens. There's an argument there if it's a desk, a countertop microwave versus a built-in. Up above it says built-in appliances. So again, address that as you see fit. Oh, I didn't mention, and it's very, very important, line 16, existing as of the date of the initial offer. I'm surprised I missed that, but I didn't now. Existing as of the date of the initial offer. So I walk in and see your house, and it's got the beautiful Wolf appliances and Sub-Zero freezer and all of this great stuff. And I'm like, yay, refrigerator, range, oven. I'm so excited with this stuff. And then I go through on the walkthrough right before closing, and there's the Costco special of the white, 18 cubic foot refrigerator and a, cruddy range that you picked up off the street. No. And then the seller says to me, what do you mean? There's a refrigerator and a range there. What are you complaining about? It's the one at the time of the offer. So if it's nice when you list it and you sign the contract, then it's got to be the same one when you sell it. You don't get to pull out the good stuff and put in something bad. Or it actually literally happened to me on my very first purchase. They swapped out the dishwasher, and I have no idea why. It wasn't a worse one or better. It was a dishwasher. It was a cruddy little, my first home, cruddy little dishwasher, and they put in a new cruddy little dishwasher. The thing is, it went from I forget if it went from brown to white or white to brown now, I don't remember. And I'm like, it's a different, it stood out. If it had the same color, I would have not even noticed probably, but it was different. Luckily, it was a panel I was able to flip over. The dishwasher worked, who cared? But you don't get to do that. If you sold the contract, if the contract, it's existing as the date of the offer, that's the appliances that stay, so be aware of that. So then on line 21, it's 1D still, we're on D, list items that could be removed but are expected to stay. An example again would be washer and dryer. If you want it to stay, you need to list it. Pool equipment is another one you see a lot. You have the pool, you got the creepy crawly, and you got all the cleaning stuff. And when you're buying the house, it's nice to get that. Well, the seller might be moving to another pool home and planning on taking it, or they might not, but put it in the contract if you as the buyer want it to stay. Then paragraph E, line 24, list items that will be removed. And again, you don't have to put washer and dryer there because it was never stated, but it doesn't hurt. You're allowed to put washer and dryer there because this way there's no discrepancy later. So if you're taking something, again, the chandeliers being the example, then list it. So D, what you're keeping, E, what you're excluding. And if you do nothing, paragraph D says what stays, and that's all that is legally obligated to stay. Okay, we are a little, no, we're right at where I'm supposed to be for a break, so that's cool. All right, so I'm gonna take some questions. I'm letting the Zoom people know. Hi, Zoom people. But yes.
I have learned just to strike out, for example, that don't have storm shutters, I will strike it out.
Okay, so the question is, do you strike things out that are not there, for example, storm shutters? Again, there's no harm in striking it out. By striking it out, you're saying it's not there. But the contract reads, owned by seller and existing on the property as of the date of the initial offer. So owned by seller, I have a leased hot water tank. It's not owned by the seller, so I can't sell it because it's a leased item. Is it a best practice to note that? Yes, that way you don't have a problem later, but contractually I didn't, by not selling something I don't own, I'm okay. If I don't have storm shutters, you can't come along and say, where are the storm shutters? I didn't have them, they didn't exist. Now, if I had them and I took them, well, no, they have to stay with the property. Like the chandelier, they have to stay. But if there are no ceiling fans or there is no intercom, who has an intercom anymore? Although you see some of these old houses and none of them work, unfortunately. They're kind of cool if they worked. But, well, I guess we all have, I can't say her name because I don't know if anybody has her here, but the woman whose name we cannot say because she'll say, how can I help you? The intercoms and things like that, if it doesn't exist at the time of the initial offer, then you don't have to cross it out because it wasn't there. But if in the interest of clarity you want to, there's, again, contract preparation class, it's okay to do so. So either of those options, okay. Any other questions? All right, we're gonna take I guess I'll go 10 minutes here. And then, so we'll come back at 10:15. So Zoom people, use your restroom or whatever you need to do. And you guys are welcome if there's any snacks left. And we'll be back at 10:15 and keep on rolling. And yep, the Zoom apparently can hear me, so we're good to go. All right, purchase price. We are at paragraph 2. It only took an hour to get through paragraph 1. So that's a problem, but let's get through paragraph 2 a little faster, maybe. So this is, again, relatively speaking, simple math. The upper right corner, line 26, is the total purchase price, including the personal property. That is the price. Paragraph 2 is what you are paying for the items in paragraph 1, property description, and it's including the real property and the personal property. So everything included in property description is what you are paying for with the purchase price, and it's the total upper right corner. Then you have the deposit. So now you all get subjected to the John Lack deposit lecture. This is solely my opinion. It is not legally binding and you can do whatever you want. But people always say to me, what is a reasonable deposit? And some people say, oh, you got to put a 10% deposit down, or you got to put this, or you got to put that. You can do whatever the parties want. The purpose of the deposit, John Lack lecture, purpose of the deposit is twofold. One, to secure that the buyer will not just cancel the contract willy-nilly, change their mind with no reason. Throughout the course of this lecture, you're going to hear ways that buyers can get out of a contract and get their deposit back. So that's not what I'm talking about. If there's a contingency that enables them to get their deposit back because they didn't get the loan or they didn't like the inspections or any of those things, that's not the conversation. The conversation of the deposit is when they do everything they're supposed to and just decide they don't want to buy the property anyway. Then their deposit is at risk and arguably the seller should end up with a deposit. So we want the deposit to be a big enough number to deter the buyer from just canceling. So by ways of example, it does depend on the property. If you have a $100,000 property and it's VA financing, which is 100% financing, $1,000 deposit might be all the money the buyer has because they're getting 100% financing. You know, hopefully they have good enough credit, they can get the loan and all of that, but they don't have the capital to put up, and they don't need it because they're getting 100% financing. So $1,000 on $100,000 is only 1%, right? Oh, you should be 5,000 or 10,000. Well, they don't have it and they don't need it because they're borrowing 100% financing. So $1,000 deposit to that buyer, they're not likely to just walk away from the $1,000. And in fact, that might be all the money they have. So if they lose their deposit, they may not be able to now buy another property because they won't even have that to put down as a deposit. So it could, even though it's a small number, it could be big enough. I jumped a little ahead. I guess I'll continue down this road and then come back. So the other side of that would be you have a cash buyer, $1 million cash purchase, and they want to put $1,000 deposit. That's silly. If they're buying for $1 million cash, they can probably afford to walk away from $1,000, and they're not really going to, not that they won't feel it, not that they want to walk away from it, but if they make the decision to do so, they may make that business decision. Is $10,000 enough? Maybe. But if it's $1 million cash purchase, you know, you might want to go 50 or 100. If they'll get their deposit back if they have a contingency, and they won't if they don't, and that's the point of it. So again, it's not a percentage that matters. It's how much is the buyer going to feel it? If, you know, will this deter them from canceling the contract? Now, to me, the important other side of that coin on the John Lack lecture is the purpose of the deposit. In addition to deterring the buyer from canceling, it should compensate the seller for the lost time on the market, whatever, you know, they take it off the market for 30 days or 60 days, et cetera. So again, $100,000 property, $1,000 deposit, it's off the market for 30, 45 days. Well, your mortgage, taxes, and insurance, your PITI is probably about $1,000, if that, especially, you know, if they own it free and clear, then just TI. But the bottom line is $1,000 probably does compensate a seller if a buyer walks inappropriately from a deal and the seller only gets $1,000. Well, they get $1,000, and that's probably enough for the month that they lost. Now they put it back on the market and sell it, and that's fine. In the $1 million property, the carrying charges for a month are probably $4,000 or $5,000 or more. So you certainly want, you know, $5,000 to $10,000 as a minimum. Again, you want to deter the buyer from canceling, so you want a big enough number there, but you also want to compensate the buyer in the event that compensate the seller in the event that the buyer walks. So I gave the examples, but I'm going to give one of my little anecdotes, which is a horrible one that also this conversation does not take into account the market. Right now, we're in a great market. So if a buyer walks, you got 6 others ready to buy the property probably. So you're not off the market for very long. You probably weren't on the market for very long. If you're keeping their deposit, it probably wasn't on the market for very long, and $1,000 might be enough even on the big property because you might even sell it for more. There's not only no loss, but you gain by the deal dying. So again, not taking into account the market. You should when you're doing what you're doing, but keep in mind, deter buyer, compensate seller. Now, my little horror story that I've been telling for a lot of years now, and I got hired after the fact, it's important to know that. So I got hired in, oh God, I'm gonna get my dates wrong because it's getting so far ago now. The contract was signed in the summer of 05, July, or I think it was August of 05. And it was a $1.4 million deal, and it was a cash deal, and it was a very wealthy man who was buying it for his new wife, and they were going to go on a honeymoon, and the closing was going to be in February, Valentine's Day, in fact, and it was, you know, going to be a surprise for the new wife, this nice $1.4 million house. He had proof of funds. It was like 20-something million in the bank, so it was all good, no problem, but the contract, again, for those of you, none of you have been around long enough probably, but it was August of 2005, $1.4 million contract. Guy dies on the honeymoon cruise. Deal obviously appears to fall apart. I get hired by the seller to try to do specific performance because the estate had the money to buy it. They were, you know, and here's the horrifying punchline. It was a $10,000 deposit on this $1.4 million deal with a 6-month closing date. So remember, I said compensation. The determinant wasn't an issue so much in this case as the compensation. So the property's off the market for 6 months. They got $10,000 to compensate. That's not enough for 6 months on a $1 million property. You know, you need $10,000 a month. And the guy's paying cash, so he can certainly have afforded to put it up. But they only got $10,000 deposit. The guy dies. We try to force the estate to buy it. There's no legal method by which we can enforce it. We get to keep the $10,000. Okay, woohoo, we got $10,000. Here's the really sad part for those of you who recognize the dates. From August of 05 to February of 06, and it might have been 06, 07, but no, it was 05, 06, I'm pretty sure. That's when the market collapsed. They ended up selling the property for $800,000. So you can all feel the pain on that one. So again, you can't account for a crazy story like that, but you can see if somebody asks for a 6-month contract, you know, markets are volatile, even good, bad, or otherwise. Get a big enough number. You might not have you wouldn't have got $600,000 maybe, because who saw that coming, but 10,000 was clearly not enough. So again, John Lack lecture, deter the buyer. $1,000 may be enough to deter the buyer. So don't think of it as only 1%. Think of it as what can the buyer afford, but it should compensate the seller also. So if it's a 2 or 3 or 4 month contract, then make it $2,000 or $3,000 or $4,000. Hey, look, you need extra time to close, then we need extra compensation in the event you don't close. And again, try to see what you think the market might do if that's an issue. But again, if it were today, you'd say, we'll sell it for more tomorrow, so who cares? But again, that's the deposit lecture. Thought I saw something there, but no. Okay, there was a question here, yeah. Oops, there were 2, okay. All right, so the question was, what if it's the seller's asking for the longer close than the buyer in this deposit lecture? Again, the goal would be to have enough to compensate the seller if the buyer defaults. So even though it is the seller that might be asking for the extra time, the buyer still shouldn't default under it. So I would still say yes. Again, it's a negotiable point. The buyer might say, look, I don't want to tie up $10,000 for 4 months because you need the extra time. And so we'll get to additional deposit in a moment, because that might be a place where additional deposit comes in. And you had a question? Yeah. My little anecdote was here in Brevard County back in 05. I forget what the property was now. Again, I was hired by the estate to try to force specific performance, which we'll get to in our default part of this lecture later, but it wasn't an available option. And they ended up, nobody fought us on the deposit, and unfortunately the deposit was insubstantial in that case. Yes, yeah. So it was a cash buyer, so we didn't care about, and it was just in his name. Yeah, so it wasn't a husband and wife. Yeah, yep. So the question for the Zoomers was, did the contract in my little story, was it husband and wife or just husband? And he had bought it in his name alone, then was getting married, and then was going to surprise the new wife, was the story. I mean, that's what I was told at the time. But again, not relevant to the deposit part of the lecture, though it is important, for thinking, ahead in doing your contracts. All right, so as to keep moving, I'll keep rolling here. So that's the deposit lecture. The very, very important that lines 32, 33, and 34. Everybody grab their pen. You have to fill in under Escrow Agent, Waterview Title Services. Okay, all right, sorry, little... Had to get that in there. All right, so the escrow agent, truth be told, I actually don't care who the escrow agent is. That's another one of those big deals for some people and not for others. I'm one who doesn't care. The issue with the escrow agent is that they be a reputable, somebody that you're going to be able to find if you need to collect the escrow or make a claim on it, and somebody who's not going to unethically disperse. So the escrow agent is governed by, I think it's paragraph 13. I'm not positive of that. Yes, I am. Look at that. Paragraph 13 of the contract governs the escrow agent's obligations as an escrow agent. And whether it's an attorney, whether it's a real estate brokerage, whether it's a title company, as long as they're a reputable company, they're bound by the terms of the contract. So even though I might be an attorney for the buyer or the seller, if I'm holding the escrow as an escrow agent, I'm not going to release it even to my own client. I might be fighting with the other side, but I'm not releasing that money, even though it's my client, until I'm authorized to do so. So again, doesn't matter to me who holds it. However, the most common practice and what I recommend is the title company who's handling the transaction, whose name you put there. Now, again, you'll have a buyer who works with Waterview Title, so I'll prepare the contract and I'll put Waterview Title in there, but then the seller selects the title. We'll get to that in paragraph 9. But if the seller says, no, we're not using Waterview Title, we're using some other company, it's okay. I can still be the escrow agent. I'll just transfer the escrow per the contract at closing to the closing agent, or we can change the contract and transfer it. It doesn't matter. Again, that's one of those, there's multiple right answers. We can do a transfer in advance. I can hold the money and transfer it later. I don't want to be sitting on somebody else's money when it's a transaction I have nothing to do with, but I also don't care. It'll sit in my account. I'll transfer it when I'm directed to. So who you put there should, best practice, be the ultimate title company. And again, in the MLS, the sellers usually put who the escrow agent is going to be. So as a buyer presenting an offer, you can look at the MLS and see who the escrow agent is and fill that in. It is important, and I think it says it in this article, but it's also one of the newer as in the last 10 years, not newer that new anymore, but the language of address, phone, email, and fax. Contact information for the escrow agent is required. I didn't know it was legally required, but this article told me it's a FREC requirement. So good, it's good to know. You need to have contact information. And the reason is, if there's a claim on the escrow, I got to know who to call to make the claim. And if it just says ABC Title, and I got no name, I got no phone number, I got no nothing, turns out they're out of business, it's a problem. So I need, accurate information for the escrow agent. So that's what you fill in for there. Now, additional deposit, you can bifurcate your deposit. So I'm going to do $1,000 now to hold the contract. I got 10 days to do my inspections. And then after I accept the property, I'll put up another $4,000. So I have a $5,000 deposit. So instead of tying up all my money during the period which I have a complete out anyway, the inspection period, I'm going to wait. And then again, in your example of a seller who needed more time, so the buyer says, look, I'll give you $1,000 now, and when we, in 30 days, I'll put up the other 4,000 or something like that. Again, so there's a variety of ways to not tie up a buyer's money, but still obligate them to it. So that brings me to a very important point, and I think I might need my glasses for this one. So if you look at line 36, all deposits paid or agreed to be paid are collectively referred to as the deposit. So agreed to be paid, if I put 1,000 now and 4,000 later, and then I breach the contract, but I didn't ever put up the $4,000, and I say, haha, you can keep my 1,000, but you never got the other 4. I can sue you for the other 4 because you agreed to pay it. And if you were in default and I'm entitled to the 1,000, then I'm entitled to the whole 5,000, and I can sue you for the 4. So a paid or agreed to be paid, if the buyer is in default, they lose it even if they didn't put it up. And again, collecting it's a different conversation and suing them and getting the money, but legally the seller would be entitled to all of the deposit, both lines A and B. So very important to note that. And I'm trying to look at my notes here. Where are we there? Okay, so I'm going to get to the calendar days stuff. I'm going to get to the date stuff in a moment. So we're going to move on to paragraph C, is financing. That's where you'll note everything has a dollar symbol except that one. There you can either put dollar amount or percentage. Personally, I prefer to put the dollar amount. I don't mind doing the math, and I like to put what the loan amount is, but a lot of people will just put 80% or 90%, and that's perfectly okay. The reason I find it interesting is, I'm going to jump ahead to paragraph E, line E rather, and that's the balance of cash to close. So you got to do the math anyway. So somewhere along the way, you got to do the math of the 80%. So I personally just do the math up front and put a $sign there. But if right, there you go. Okay, so same, again, different programs will, in the audience, she said that the computer actually does the math for you, and that's great. Some do, some don't. Doesn't matter if you're doing it by hand, whether you put 80%. The advantage of putting the percentage is if you're negotiating back and forth with the purchase price, it's one less line to change, but the truth is you're changing every other line anyway. So again, that's one of those, whichever way you prefer to do it. But we'll get into paragraph C when we get to paragraph 8, more detail on it. But it is, they revised the contract. I think this is the 2014 revision or 13 revision. But it used to be in paragraph 8, there was a place for a dollar amount of the loan you'd be applying for, and we'll get to that later. However, they've done away with that, and they put in reference to paragraph 2C. So when you're applying for a loan, you're applying for a loan in the amount listed on paragraph 2C. So it is very important that if you're applying for a loan, that dollar amount be put in there, dollar or percentage. But again, it's not the kind of thing you can leave blank and come back to later. You need to have that there. Now, paragraph D, other, again, I put in my little sample, it can be a gift of equity, a second mortgage, a purchase money mortgage, et cetera. Now, if it's a true purchase money mortgage where the seller is providing all of the financing, then that would go under C, under financing. And when we get to paragraph 8, it would be 8D for seller financing. However, you might have the seller giving a simultaneous second. So they're borrowing $80,000 from the bank, but the seller is willing to give it 15%, you know, $15,000, my $100,000 example, 15% second. So you could put their purchase money second to seller 15,000 or whatever. Gift of equity, again, parents selling it to the child, and the child, you know, $100,000, they're getting an 80% financing, but the parents giving the other 20%. So you can put $20,000 there as gift of equity from the seller. Again, anything, the other thing was a thing of value, I think I put on there, right? No, I didn't put that, but an example that I have had, a live example, the buyer gave the seller a boat, and the boat was worth $10,000. So we put boat, $10,000. And it was a credit, you know, a credit to the buyer for this exchange of the boat. So again, and other is any credit to the buyer, not necessarily a debit from the seller, depends on what it is, but it's a credit to the buyer, whether it's a borrowed credit, you know, borrowing money or giving something of value, but it's a credit to the buyer. Then you get to the balance of cash to close, not including buyers' closing costs, prepaids, and prorations. In other words, this is not their bottom line at the closing. This is the bottom line on the contract. And the way it's going to read is line 26 is the purchase price, $100,000, less the $1,000 initial deposit, the $4,000 second deposit. So that's a total of $5,000 deposit. They're borrowing 80% financing, which is $80,000. There's no other credit to them. Cash to close, $15,000. That's how the math will read. So it's number minus, 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 minus number. Yes?
For escalation addendum, not for that, or is there any?
That's a great question that I'm not adequately prepared to answer. The question was, what we're seeing these days now are escalation addendums, and I should have read through that and I didn't. So I apologize for not being ready for that question. But an escalation addendum is in this really weird world we're in. So if anybody's watching this, you know, in the future, right now in 2021, we are in a crazy market where we're getting multiple offers and we're doing highest and best, and buyers are coming in and saying, look, my offer is $100,000, but I'm willing to go up to $105,000. If anybody offers 104, I'm willing to go to 105. Now, I have not read through there is, I think the FARBAR, or the Association of Realtors, created an escalation addendum. I have not read it. So again, full disclosure, I haven't read the actual addendum. But my understanding of it would be what I just described, where we're willing to go higher if needed because we really want to be the highest and best. And again, that we have sellers now saying no escalation addendums, give us your true highest and best. And so it's a really, really weird market. So I would guess the escalation, that would be a place to use the 80%, because if it says 80%, and you've bumped up the purchase price to 105, now it's 80% of 105. So if you're going to do one of those escalation things, I revert my comment of doing math and instead put the percentage in, because that'll self-effectuate your issue. And the balance of cash to close, I don't say it doesn't matter, it's important, but it really doesn't matter. The balance of cash to close is going to be what it's going to be when the title company puts all the numbers together. You got your purchase price, all of your credits, and this is your balance of cash on the table. So the one last thing, and then I'll get to your question, is if your balance of cash to close is a negative number, it's 100% financing, but you put a $1,000 deposit down. So you have two choices. You can put either in parentheses or a negative 1,000. In other words, the buyer comes to the table with negative $1,000. I always put 0 there. Again, this is personal preference. Instead of putting the credit of $1,000 on line E, I prefer to put a 0, thus not creating the expectation in the buyer that they're going to get $1,000 when it closes. Because the truth of the matter is it's exclusive of closing costs, prepaids, etc. So they're not really going to get that. They're going to get credit for it, but they're not going to get a check at the table almost certainly because of closing costs and other expenses that are going to eat that. So I always put a 0 when the math adds up to a negative number. So did that help with your question as far as the escalation? Oh, yeah, sure. Okay, so the question now is, with the escalation clause, can you put it on other line D? And sure, again, there's nothing, I have no problem with parenthetically saying see escalation clause. That way, somebody looking at it will know, hey, wait a minute, it might change. Again, I like to look at the escalation addendum before I make too much more comment on that, but putting it under other certainly wouldn't be a problem in that regard. And we had a question here.
Yeah, just a side point. I personally don't prefer, if you're in a counter offer mode, I prefer having a counter offer form with buyer and seller's signature, not cost to the price.
Right. Okay, so the question on the table was the difference between using a counteroffer form for going back and forth negotiating the purchase price versus just crossing it out and initialing. And again, to me, that's a personal preference. The counteroffer, I mean, they're both legally binding. They're both legally acceptable. It is certainly cleaner to use the form because it's, it's something to reference to, but it's cosmetic. Legally, it doesn't matter. You can have a contract with 1,000 scribbles and crossouts and it's legally binding. It's just ugly. And it's important that those crossouts have initials and some can be missed. And then when there's a fight down the road, I actually have one. I think we've resolved that part of it, but there was a very big issue on the effective date because a change was made and the contract that was sent to me as the seller's attorney attempting to get out of the deal or cancel the deal and keep the deposit was the effective date, and they were a day late on the deposit. I'll get to that in a moment, but then I get a new version of the contract that had an initials with a date that the date, which we'll get to in just a second, is the last date that everybody initials it. So again, the counteroffer form might definitely be cleaner in that regard because it's a form that'll be signed and dated, et cetera. And yeah, so the issue is using that form versus doing it manually. It's cosmetic. It doesn't legally matter. So if your preference is the one, I respect that preference and think it's a good one, but it's not a necessary way to go. All right. It is, again, I have a little note here. Very important to know, notwithstanding that it says, by wire transfer or other collected funds. Wire transfer, just let your buyers know they're going to have to wire the cash to close. They can't show up with a cashier's check. They can't show up with a regular check. They can't show up with cash. They have to wire the money, and it's not that big a deal. Yes, it's annoying. You got to go into the bank. You got to do the wire, and it's also critically important in the world of fraud we're in to verify the wire instructions before you send the wire. So make sure your buyers know to verify. Call me, confirm the number, the account number, and the ABA routing number. Go to the bank, send the wire. But it's got to be that way. We can't take personal checks we're not accepting cashier checks of all the fraud in the world. Again, I won't say there's never an exclusion to this comment, but just assume there's no exclusions and that they have to do wire transfer. Okay. Again, as always, I'm running long. I'll try to keep going faster, but any questions on purchase price or any of that? Yes, ma'am.
Yes, I started to learn to fill this stuff, and I have broker said that if they're not giving an
initial deposit.
NA, and then if they are not giving any other at that point, to put NA.
Okay, so again, for those in Zoom, the question on the floor is putting not applicable or NA next to places on line B for additional deposit and or D for other if there is no additional deposit or there is no other. So I'm going to answer that with the generic answer to all things blank. If there are, again, different perspectives on this, a blank is okay. We're going to cover in the contract, there are places where blanks, if left blank then, and it actually has some meaning. There are other places where a blank is just a blank. So if line B, as in boy, additional deposit is blank, then there is no additional deposit. If you want to put 0, if you want to put not applicable, that's perfectly okay because it's accurate. So you're allowed to fill in the blank with a space holder so that nobody later fraudulently adds something to the contract. That would be the reasoning behind filling in the blanks, is so somebody can't cheat and add something and say, look, it had, like in my case, I wonder if the guy really initialed it after the fact or not. I don't know, I don't care, but it could matter. So by closing off that possibility by putting something there, absolutely nothing wrong with that. Is it necessary? No. If it's blank, it's blank. Obviously, there's no additional deposit. And again, short of fraud, there's no deposit, there's no deposit. So whether you fill in the blank with a not applicable, with a 0, with a little dash, or you just leave it blank, as long as it's not one of those blanks, which we'll get to in a moment, that says, well, actually, I forgot to do it. Line 29, I'm glad you brought that up. Line 29 is the offer either A, accompanies the deposit accompanies the offer, or B, is made within blank, and then here's a perfect example, if left blank 3 days after the effective date. And then it goes on to say if neither box is checked, then it's option 2, which would be 3 days if left 3 days. So if you did nothing on line 29, the deposit's due within 3 days. That's what the contract says. I like to fill in blanks the way you do. I don't usually put the not applicable, actually. I leave that blank, so it's interesting. But I do like to put the 3 in there instead of leaving it blank. I don't know why, I just do. So nobody puts it in a 2 or a 4. But as to when that deposit is due, so this is the important part of this. A, as a title company, I don't like it to be a company's offer, because that means they're obligated to give it to Waterview Title, and I'm obligated to take it and deposit it, and then they don't even accept your offer, and then you say, give me my deposit back, and I'm like, well, I got to wait for your check to clear. So again, I don't want to take money on a deal that's not a deal. So as a title company, as an escrow agent, I prefer it to be made after the effective date. So I know I have a live contract, not an offer that I hope becomes a contract. So that's my feeling on line 29, 1 or 2. I prefer 2. Now, how many days? The 3 if left blank. And this is where I was just telling you about my case. It is critically important. The deposit is due. We're about to get to it. I think it's the next screen. Yes, it is. I even jumped there. So I'm going to get to that in just a second. But the effective date, time is of the essence, and if a deposit is due 3 days from the effective date, it's not due 4 days from the effective date, it's due 3 days from the effective date, and if they don't make it in 3 days, they're in default. If they make it on the 4th day, too late. They were already in default on day 3 when they didn't make it. So if you got a buyer who's going out of town, or there's some question as to your ability to get that deposit in, if you need to put 4 or 5, make sure you do it, or make darn sure your buyer gets the deposit in a timely manner. Because the case I was telling you about, we were holding them in default for not making a timely deposit. And then he was able to evidence that it was timely because the effective date was 1 day later. And again, we decided not to fight over whether that was true or not. We accepted it and moved on. But it's important to know that if you there are scenarios where a seller might want the deal to die. And so if the deposit's not made, they call me up to cancel the deal because it was in default. So again, very important to know that you must get the deposit in. And I'll get to that other note I have in a moment. So, okay, I think, do we have any other questions? Okay, we're going to get to that right now. So, yeah, again, it's a good question. So the question was calendar days, but here we go. So we have two screens we're about to go over, that one and that one. So time for acceptance and effective date. So the blank on line 45, you're making an offer, again, okay, quick legal conversation. An offer is I am offering to either sell my property to you on these terms and conditions, or I am offering to buy your property from you on these terms and conditions. Whoever signs it first is the one making the offer, and whoever signs it second is the one accepting the offer. The overwhelming majority of the time, the buyer is offering to purchase the property from the seller. So the rest of this conversation will assume that. The buyer is making an offer to the seller to buy the property, and they're giving the seller until on or before blank to accept the offer. Otherwise, it shall be deemed withdrawn. So an offer can disappear in, I still haven't written this down, and anybody watching this for the last 15 years will say, when are you going to write this down? And I don't know, but I believe it's 5 ways. An offer can be accepted, in which case we now have a contract, yay, or it can be rejected. So we don't have a contract, boo, but that's the end of that. It can be counter-offered, which is the equivalent of a rejection, but now there's a new offer on the table for the buyer to accept the counter-offer. It can be withdrawn, which if I make an offer to you and I give you a week to accept it, but 2 days later I say, never mind, as long as I withdraw it before you've accepted it, then it's withdrawn. I have the right to withdraw an offer before you accept it. Therein lies the next set of litigation, which happened first. I accepted it. No, I withdrew it. So we have to prove who did what. But legally, I can withdraw it before you accept it, or it can expire. There's my 5. So expire is what we're talking here on line 45. Put in an expiration date. Now you can use that any way you want. You have till tomorrow at 5 o'clock to accept it. You have till today at 5 o'clock to accept it. You have a whole week to accept it. Take your time, think about it, do whatever you want. Whatever you want strategically as a buyer, I'm again assuming buyer, the seller has however much time you give them to accept it, unless again you withdraw it. If they don't accept it by the deadline, then it is deemed expired. I'm going to jump ahead in my conversation, if the seller accepts it after it's expired, that effectively is a counter offer. The seller has accepted it, but it already expired. So really the seller is making a new offer by accepting your offer on the same terms and conditions. So it's not a counter offer other than the date, but it is a counter offer. So the buyer needs to acknowledge the acceptance. And this is one of those multiple ways to do the same thing. You can change the acceptance date, which is probably the most common thing, and have everybody initial the acceptance date to be the expiration date to be when both parties accepted it. I don't feel that that's necessary, but again, it's perfectly okay. What is necessary is if the seller accepts it after it's expired, as I say, that constitutes a counteroffer. So you need something evidencing that the buyer accepted the seller's counteroffer, late acceptance of their initial offer. And again, I don't personally care how you do it. If you want to do it by changing that, initialing it, if you want to do it on a contract, the effective date of this contract is, if you want to send an email, we hereby accept it and deem the effective date to be, as long as somehow it's documented. Now we fast forward to to my conversation if you're standing in front of a judge. Can you argue that the seller accepted it a day late, but the buyer accepted the acceptance? If I have an email that says, we've got your contract, the effective date is hereby deemed to be July 13th. I have that email. I'm going to win if I go and stand in front of a judge and say, Your Honor, they're trying to pretend we didn't have a contract. It was after the acceptance date, but here's an email saying they accepted it. The other thing is the truth of the matter. If you're standing in front of a judge, the buyer has post-acceptance applied for a loan, done inspections, proceeded through the contract, it's going to be very hard pressed for the buyer to say, oh, wait, we never had a binding contract because you accepted it a day late. Again, they could do that the day of, never mind, the offer expired, I'm moving on. But if they proceed forward, they're probably not going to be able to pretend they didn't have a binding contract. However, I would document it with at least an email, some communication that you could show the judge if you had to. So that's my feeling on that. Now, why is it so critically important to put the expiration date? If you left it blank, and or if you put a week, here's my standard story. Saturday, you go out with your buyers, you find a beautiful property, you love it, you put in an offer on Sunday, and you give them 7 days to accept it, and you never hear from them. They don't reject it, they don't accept it, and you figure they just moved on and they're just rude, and you go out on Saturday and find another property, and you put in a contract then, and then you get 2 acceptances in the mail, because the one hadn't expired yet, and the other is a new contract, and now you're legally bound to 2 contracts. Now, again, in this contract, you'd be able to get out of it because of an inspection clause or something like that anyway, but on a pure technical basis, you are now legally contractually obligated to 2 different properties because you didn't withdraw that and they accepted it, you know, before it expired. So again, make sure you fill in line 45, make sure you know what the date is, and if for some reason you want to withdraw it, make sure you withdraw it in writing before it's accepted. So that covers that. Then we get to the effective date of the contract is the date when the last one of the buyer and seller has signed or initialed and delivered this offer or final counteroffer. So again, if we're going back and forth and we're making changes, it is the final document with the final set of initials that is the effective date. And again, in my case, this guy purportedly dated his initials, which I think was done after the fact, but that's beside the point. There was a date of his initials, so that became the effective date because that was the last change and delivered it to. Delivered is important because if I sign the contract Wednesday night, but we don't send it to the buyer until Thursday, it wasn't delivered till Thursday. The effective date is Thursday, not Wednesday. And why is that relevant? Because here's why it's relevant. Time. And I didn't do this. This is in the contract. Time is of the essence is bolded on line 420. Again, that's standard fare. Almost all contracts will have a time is of the essence clause. What that means is any provisions in the contract that have a time frame are essential provisions. They're not random, they're not on or about, they're not, estimates of when something might occur. It is an essential provision. If I put 3 days, I mean 3 days. I don't mean 4. If you have X amount of time to do something, that's how much time you have. And if you fail to do it, you're in default under whatever the provision may be. So time is of the essence. Now, very important to know what time means. Almost all contracts will have a definition of time. We're only going over the FAR bar as is 5X or whatever version you're looking at contract. That reminded me of something that I have to say in a minute. But we're going off of this contract, and this version of the contract reads calendar days used in computing time periods. However, if a time period ends on a Saturday, Sunday, or national legal holiday, then it extends to 5 p.m. of the next business day. So if you have a Saturday, Sunday, or a holiday, Memorial Day or something like that, it will actually be the following Tuesday. Even though you thought it ended on a Saturday, they might have until Tuesday. That would include the inspection periods. That would include the deposits. That would do, let's see, I think the deposit wasn't excluded right now. Actually, let me double check one thing. I said deposits. All right, I'm going to ignore that. I'll get to it later if I have to correct myself. But the bottom line is, time is of the essence. In this contract, it is calendar days. You may someday be presented as a seller with a buyer who has presented you a different form of contract. Either the FAR contract, FAR, for Florida Association of Realtors, has their own version of contract that is different than the FAR bar contract, which is what we're doing, which is the collaboration, the Florida Association of Realtors and the Florida Bar. So we're going over the FAR bar contract. That has become the standard in Brevard County, but there is a FAR contract, and there are other contracts throughout the state. So you might get somebody from South Florida who presents you with a Broward County contract. And again, it's the same, it's fine, there's nothing wrong with it, but some of the provisions may be different. One of them that may be different, and I'm not suggesting it is, but would be the time. And it could be business days instead of calendar days. And back in the day, the day being 2003, 4, 5, when things were going so crazy fast, kind of like they are now, I had a client, we had a seller who said 30-day closing, not 30-day closing, 30-day for loan approval or something like that. There was a time frame, and my client needed a little extra time. So I pulled a different form of contract and submitted it. I didn't mention anything. I just said, here's our offer, but I used a business days contract instead of a calendar days contract. So I effectively bought my client 4 weekends, because a business days contract is exactly as it reads. And so instead of counting calendar days, you count business days, and you basically buy in a month, you buy about 8 days. So be aware if somebody presents you with a different contract to look up what time means, because it could be calendar, could be business, or it could be a hybrid. A hybrid is where it says if any time period 5 days or less shall be business days, and more than 5 days is calendar days. And that's what our form used to be. A few years back, it was a hybrid where less than 5 days was business and more was calendar. And it was one of those where 5 days and 7 days were effectively equal. And 6 was bad because it was in the middle there. But in any event, so be aware of time, and the effective date is critical, and documenting it. There is a form of contract that has a box that's where the parties actually write in acknowledging the effective date. That would have come in really handy in my most recent case. I like to try to document it with an email. Okay, this will confirm that we are under contract and the effective date is July 13th. That way, if there's a problem, they say, no, wait, it's July 12th. And then we hash it out immediately, where time is of the essence, but it's not going to matter all that much because we're on day 1. And if I only had 3 days, I might only have 2, but I still have 2, and I can argue that I need extra time. But you don't want to wait 10 days when something was due in 5 and say, wait a minute, it was due back then, or whatever. So it is a good idea to document. Again, an email counts as document, but somehow acknowledge what the effective date is, because time is of the essence, and because there's a lot of provisions that run from that date. It is very important to know when that is. Yes. Okay, so so the question is, if we had a 6 p.m. Saturday counter from the seller. So again, if you look on line 46, unless otherwise stated, the time for acceptance of any counter offers shall be within 2 days after the counter offer is delivered. So if whatever change you're talking about in the contract constitutes a counter offer, which any essential provision does, then the buyer will have had 2 days to accept that counter offer as far as that goes. And if they've accepted it within the 2 days before, again, the seller could withdraw it theoretically, or put a limitation. It says unless otherwise stated. So the seller could put in there, I'm making this counter offer and you have till tomorrow at noon to accept it. Again, that's something they could do. But if they just initialed it and send it back to the buyer, then the buyer effectively has 2 days to accept it. Now, again, the 2 days are calendar days, and if it ends on a Monday, if Monday was a holiday, it would extend to 5 p.m. the next business day. So I think that's answering your question. What's that? And it was because it was, yeah, we're talking about July 4th in this case. So yeah, so in the scenario for those of you on Zoom, if we did it on Saturday, July 2nd, oh no, actually it was the 3rd, the 4th was July 4th, but the 5th was the national holiday. So very confusing, but the punchline is the 5th was the national holiday as defined on line 423 there, and therefore would extend in 5 p.m. of the next business day. They didn't have to unless, again, line 46, unless otherwise stated. So if the seller in their counter offer said, you have until X time to accept, otherwise it's withdrawn, that is their right to do so. So if they otherwise stated and only gave you a limited amount of time to accept it, then you either accept it or you don't, and the seller is within their rights to say my counter offer expired. So again, the facts do matter, and I don't have time for enough of them, but we can discuss it after if it's a live thing. Okay, so where are we at? 11:05. Let me get through page 1. So I'm going to hang on to you and through page 1, and then we can take a break. So closing date. There's only 3 things on here, so that shouldn't be too bad, right? That you would think. Okay. Again, I've had discussions with brokers who disagree with me, and I'm okay with that. This is the John Lack preference, not a legally binding preference. I like to put on or before, and the reason I like to do it is from years of practice with lenders, and again, coming at it as a title guy more than as a realtor. The banks, if the bank sees on July 30th, and we want to close early, the bank says, I need an addendum because the contract says July 30th, and if you want to close on the 22nd, we want an addendum. And I am inherently lazy, so I don't want to do an addendum if I don't have to. So I put on or before. Now the bank doesn't need an addendum because we already accounted for it in the contract that it's on or before. What I explain to my clients and the other side is July 30th is the outside date. That's the closing date unless the parties, both parties, agree to close early. So if the buyer says, it says on or before and I want to close on the 22nd, and the seller says no, the buyer, in my opinion, and I've never seen my opinion overturned in court, doesn't mean it couldn't happen, but the buyer can't make the seller close early, nor can the seller make the buyer close early because it says on or before. It just gives them the flexibility that if they both agree, we don't need to do an addendum to the contract because of a lender. That's my philosophy. It's never failed me. I've never had to fight over it, and that's what I recommend. I have heard brokers say we want a fixed date for whatever reason. And again, there's no harm in it. If you put on a date, then everybody knows what date it is and there's no question and we've all agreed. And if you want to change it, you do an addendum. It's not that big a deal if everybody agrees anyway. So that's my opinion. I put on or before. You guys do as you see fit. One thing, again, it's funny going now in 2021, when I started this class in 2006, for those of you who don't know, the iPhone came out in 2006, but we did have flip phones and we had other phones in 2006. And I always said, how many of you have a phone? And most people did or had a flip phone. And I always said, look at the calendar on your phone and make sure that the date you're putting is not a Saturday or a Sunday or a legal holiday, and make sure, stupid as it sounds, the date exists. Don't put February 30th. Don't put November 31st. I've seen both of those. It doesn't exist. I don't know what the interpretation would be. Is November 31st actually December 1st, or is it actually November 30th? I'm not sure. And February 30th, that was the silliest one because at least put the 29th, right? And hope it's a leap year. But if you put the 30th, is that really March 2nd, or is it February 28th? Yeah, I don't know. So, or do we not have a contract because you put a non-existent date? I don't know. So interesting legal arguments that might be fun for an attorney who likes that sort of thing. But for you guys, look at the calendar. And then the other thing is check. I have one on my desk now that reads August 15th, which is a Sunday. So we're not closing on Sunday. Now, if the goal was to close Friday, well, either party could say, nope, we're closing Monday because it extends to 5 p.m. of the next business day. So if it ended on a Sunday, it becomes Monday. So that brings me into my third comment. Does not have to be the last day of the month. Everybody puts the last day of the month. Everybody does it. And the theoretical reasoning, I think, is prorations and prepaid rent and things like that. When you close, you pay rent from the day of closing to, not rent. You pay interest on your mortgage from the day of closing to the end of the month, and your first mortgage payment is due the first of the following month. So if you closed on the 30th, you paid 1 day of prepaid interest, and your mortgage payment would be due on September 1st. If you close on July 15th, you pay 15 days of prepaid interest, and your payment would be due September 1st. mathematically, it's a wash. You're paying what you're supposed to be paying. Who cares? But it is more money at the table. And I think that's the reason buyers put the end of the month, at least one of the reasons. However, since all of you do it, as a title company, I sit around twiddling my thumbs from July 1st to July 28th, and then I got one person who put the 29th instead of the 30th, and then I got 17 people on the 30th, and I'm alone now. So I'm trying to do 17 closings starting at 9 a.m., and I'm going till 9 p.m. trying to kick them out, and the first one gets delayed, of course. And so the domino effect, the last closing is sometime midnight, 1 o'clock, 2 in the morning. So again, I'm exaggerating, obviously, and title companies should be able to handle it. But the banks too, the banks are all closing at the end of the month. Many, if not most, banks require a funding authorization. As a title company, I have to scan the closed package to the bank. I have to wait for the bank to review it and tell me it's okay. And then I'm authorized to fund. That can take anywhere from 30 minutes to 2 hours. And sometimes you're just sitting there in the conference room waiting while the next closing is waiting, and or the moving trucks are waiting, or whatever. The banks are slower on the last day of the month. When the last day of the month is a Friday, forget about it. Then it's just misery. So the punchline is you don't have to do the last day of the month. Pick your favorite number. Mine is 22. I do all my contracts on the 22nd. Not really, I should. But look at the calendar. Again, one of the things I do personally is I try to do it a week ahead of the last day of the month. And if I represent the buyer, I try to do closings on a Friday. If I represent the seller, I try to do closings on a Monday. My theory is I give my client the weekend. But again, do it however you see fit. Middle of the week is easier for title companies because they're not as busy as they are on the Friday and Monday. But again, however that works. But look at your calendar. Make sure it's not a Saturday, Sunday, or holiday. Don't be on the first of the last day of the month. And we will take another, let's go 8 minutes. It's 11:12, and we can be back by 11:20 because I still have a lot left to do. But we made it through page 1, 2 hours, page 1, and we only have 11 pages to go. So I'll sit up here and accept questions, but otherwise I'll see you in 8 minutes. Time I'm used. So again, I will attempt to pick it up. We'll see how well I do. Okay, we are getting started again in the back there. Excuse me. Excuse me. We're getting started. And we're live on Zoom, so hi, everybody. Okay, so again, we're going to pick it up here. For those of you, we're going over the contract. The materials that were given to you are the newer version of the contract, which is revision June of 2019, and it's the Florida FAR as is 5X is what's in your packet. But I've been reading off of, and my slideshow is the 5, which is the 4/17, April 17 revision. The only difference, and that's why I did not change my slideshow, is on page 11, the addenda. And for those of you on Zoom, I'll hold it up so you can see. The addenda, they added a CC, as in Charlie Charlie, for a Miami-Dade County Special Taxing District disclosure. That's the only change between the contract I'm reviewing in my slideshow and what you're looking at. So if you noticed, or if you notice at some point that they might appear different, the only difference is Miami-Dade has a Special Taxing District disclosure, and they added that to the contract as an addenda, and they made a clause for that addenda. Okay, are you getting on, you're on assigned bill, are you on paragraph 7? Okay, you're ahead of me because I'm on paragraph 5. So we will table that question. Zoomers, you don't need to hear it because it didn't matter. You'll hear about it soon. So here we go. We are going to, again, I'm going to try to pick it up, but I'm not really great at that, but here we go. Extension, so the CFPB clause is the Consumer Financial Protection Bureau. It came out in 2014-15 is when it kind of became established. It took everybody in the industry 2 or 3 years to figure it all out. I think we're all there now. So you, especially you new folks, have probably only seen the closing disclosure. People prior to the new folks used to deal with the HUD settlement statement, and there's the 2010 version, which changed everything. And then prior to 2010, we had a settlement statement as well. So again, there have been a variety of things called settlement statements. Our current world uses what are called closing disclosures, and it all arises out of the CFPB. And the important part here is we talked about the closing date. We're going to talk about some other things, but it's important to note, and let me get I don't need my glasses, I guess. Line 56, the closing date shall be extended, not may, but shall be extended if any of the required closing disclosures have not been timely provided. So without getting into too much detail, the CFPB requires, that's for borrower, it's a lender rule. And if your buyer is a borrower and they're getting, institutional financing, then their lender is required to give them a closing disclosure 3 days in advance of the closing. And they have to acknowledge receipt of that 3 days in advance of the closing. And if they fail to acknowledge receipt 3 days in advance, then the closing shall be postponed because the lender is legally prohibited from lending the money until they've had the 3 days. So again, lots of problems in 2015, 16, 17, but we've worked out most of the kinks. And so now it's not that big a deal. However, it does still happen where a closing disclosure is not provided. The closing is supposed to be Friday and it's Tuesday and the bank rushes it out. But unfortunately, the buyer doesn't click acknowledge until Wednesday. And so now the bank can't close on Friday because they need to have they have the 3-day disclosure. So now the closing is postponed till Monday and there's nothing to do about it. And the seller can complain all they want, but the contract provides that it shall be extended. It's not optional. It's not, when you sign the contract as a seller, you are acknowledging that the buyer is bound by these rules. And if they don't happen, then it shall be extended. Now they do put a limitation of up to no more than 10 days. But again, be aware, not that you have to do anything, not that it's a big deal, but be aware of it and stay on top of it so that it doesn't become a problem. Force majeure, I cut and pasted that paragraph G from the standards. So it's not really there chronologically in your contract. You can see it's line 425. But force majeure is what are typically known as acts of God. But it's not just acts of God. If you read it on line 428, hurricanes, floods, weather, earthquakes, fire, and other acts of God, but it also includes wars, insurrections, acts of terrorism, things of that nature, which by the exercise of reasonable, diligent effort, the non-performing party is unable to prevent or overcome. So again, one of the other provisions is if you can't get insurance, it's not the buyer's fault if there's a hurricane and they can't get insurance and they can't close on a property, and you don't want them to close on a property if they can't get insurance. So closings may be delayed up to 7 days. And again, this is a shall. It'll be extended up to 7 days after the event no longer exists, not to exceed 30 days. So again, we're in hurricane season. There may be delayed closings. There, God forbid, may be a hurricane that further delays closings. But once the event is through, you have 7 days after the event to close. And again, the parties are contractually bound to the contract, and this is one of the contractual provisions. So again, part of my plan here, that some of which will be edited, unfortunately, but part of my plan is to teach you what's in the contract. This is not contract preparation. There's no blanks here to fill in, but I want you to be aware of some of the terms of the contract so that you're prepared to address them in advance with your client so they realize that there might be a delay if there's a hurricane in the box, or there might be a delay if there's financing and there's, some questions. If we did a tight, again, it won't matter on a 30-day closing, but if somebody tried to do a 20-day closing, it might not happen because it's a CFPB or something like that. So that's that. Moving on to occupancy and possession, there is a checkbox here. So if occupancy is to be delivered at closing, occupancy and possession is to be delivered at closing. There are other states that do it differently. I'm Florida born and raised, so all I really know is Florida, but I'm old enough and wise enough now to have learned from other states. So I do know other states do what they call dry closings, where everybody does everything, money, deeds, all of that, but the closing's not done, then the seller moves out, and then they do their walkthrough, and then they release the deed and the money. So they do the closing as a dry closing, and then they deliver possession. That's not how it's done in Florida. Not that you can't negotiate it, but that's not how it's done. In Florida, you show up to the table with the keys. You've already moved out of the house. It's not, I'm at the closing, okay, great, now I'll go back to the house and get my stuff. No, once you've closed, it's not your house anymore. You don't get to go back. It's occupancy and possession is delivered at closing, again, unless stated otherwise. So be very aware of that, because it's very important, because I've had plenty of times where sellers leave stuff and then it becomes a problem. Now, part 2, line 68, if the property is going to be subject to either leases or other occupancy after closing. So there's 2 pieces of this puzzle. There are leases for rental properties when they are tenants, not the owner, seller, landlord, but the tenants in possession. This is a loophole that's very important that you be aware of. Again, we talked about me playing the bad guy and trying to get somebody out of a deal that the other party wants to stay in. This is one of my secret loopholes. So I'm giving away a secret. Line 71, if the property is subject to leases, the buyer shall have, well, first, the seller shall have 5 days from the effective date to deliver any leases. Leases, not, hey, yeah, there's a tenant in there. No, you got to say, again, if it's a verbal lease, then I guess you have to note that in some fashion. But you need to deliver the leases to the buyer within 5 days of the effective date. Now, that is, again, within 5 days. So the question is, are they in default if they don't do so? A, possibly, but B, more importantly, in the effort of getting out of a deal, if they haven't done it, the buyer has 5 days after receipt. So if you didn't do it till 10 or 15 or 20 days, the buyer still gets 5 days to review the lease. And again, very important language on line 71 again. If buyer determines in buyer's sole discretion, and I'm going to reiterate sole discretion in the inspection period as well. Sole discretion means the buyer sole discretion. They can like it, they can not like it. They don't like the font you used on your lease. The lease is wonderful. It's $1 million a day, but the buyer doesn't like the font. So they bail out of the deal. Sole discretion means they don't need a legitimate excuse. They just need something to hang their hat on. In my discretion, this is an unacceptable lease. So the buyer can terminate the contract within 5 days of receipt of a lease. So again, big old loophole. I've had buyers who won out of a deal. It was a rental property, and the seller hadn't delivered the lease. So I come in, I say, hey, we need a copy of the lease. Oh, look at that. That's on, you use 20-pound paper. I only use 24-pound paper. Excuse me. That's not acceptable. We're out of here. So again, it's silly, but it's true. Close that loophole. Make sure you give them a copy of the lease. Now, the other part would be post-occupancy. There's 2 versions here, pre-occupancy and post-occupancy. And again, as an attorney, as a realtor, this not really as a title company, avoid pre- and post-occupancy agreements at all costs. Don't let buyers in early. Don't let sellers stay late. And here's why. You let a buyer in early, no matter how much they love the property and are excited to get in, the minute they're there, that's when the blemishes show up. That's when all the little things go wrong. They haven't closed yet. You've let them in before closing. That's what pre-occupancy is. And now they realize, wow, this isn't the dream home we thought it was. We're not going to buy it. Now, again, we have issues of deposits and all of the defaults and all of that, but forgetting that, they're in possession of your property now, and you now have to either evict them or reject them and legally throw them out. Now, of course, they may voluntarily leave, or they might not. They might like, you know what, we don't really want to buy this place, but we don't have another place to move yet, so we think we'll stay here until we find something else. And you got to go through a court process to kick them out. You'll win, but you got to go to court to do it. So you don't want to buy her in advance. And then the flip side, seller. Hey, I just need another week. We're closing on our home next week. Instead of making us move twice, do you mind if we stay an extra week? Sure, no problem. We're friendly. We're nice. Their closing falls through for whatever reason. They have nowhere to go. They're like, you know what? We're just going to find another place. But until we do, we're just going to stay here. And you're going to be like, heck no, get out of my house. And we'll be like, yeah, we will. We're just not ready yet. And you got to evict them. and you got to get them out legally. There's no self-help in Florida, so you can't throw them out yourself. You got to get the sheriff to come after a court order to throw them out. So you don't want buyers in early. You don't want sellers in late. That said, it happens all the time. We do it all the time against our own better judgment. And again, we're nice people. We're trying to help out either side. It is a lease agreement. They call them pre or post occupancy agreements. They tend to be shorter than the long lease. But the bottom line is the owner, whether it's the buyer or seller, the owner of the property is a landlord and the person in occupancy is a tenant, and you want a lease agreement. You can call it a post-occupancy agreement, but you want an agreement that provides for eviction, that provides for attorney's fees, that provides for who's liable for, you know, the utilities and damages and all of that, just like a lease. So if you're going to do it, either get an attorney. Again, some brokers have forms and stuff, but it is a legal document. You can't prepare it yourself. You're not attorneys. So either get somebody who's authorized you to use their form or have somebody prepare it. And again, it's not a big deal. Both parties should agree to it, but it is a lease. It's a short-term lease. It could be for a weekend, but get it in writing so that if you have to kick them out, you have a legal piece of paper and an entitlement to fees and cost in the process. So that's my little conversation there. Any questions? Good. Okay, so here we get to your question on assignability. This is one of the few places that has 3 boxes with no default, which is surprising a little bit, but it is what it is. So if you don't check any of them, there's no default written in the contract, but the law provides the default, and the law is all contracts are freely assignable unless otherwise noted. So if you don't check any box, then you've effectively checked the first box, even though it doesn't say that. Not sure about the release from liability, actually. So they're freely assignable, but I'm not sure where the liability provision comes. So it might be box 1 or 2. It is not box 3. The law does allow assignment if it doesn't otherwise state. My comment on this, my handwritten notes are: best practice, check may not assign. A seller can always change their mind and allow an assignment, but they shouldn't upfront give that control away. And the provisos on that are, you know, clarify if it's necessary. If I'm checking the assignment box because I'm doing it in my name, but I really want to assign it to my children or to my LLC or to my family corporation or to a trust. So I want the assignability because I plan to assign it to some purpose. If the seller is aware of what the buyer's intentions are, then it's okay. It's not wrong to have it be assignable, but best practice for the seller is to retain the control on that assignment and not allow the buyer. And the reason, again, my little sad story, so to speak, there's contingencies in the contract. The contract says I have to get a loan. I would qualify for a loan, no problem. And I decide I want out of this deal and I don't have any other out clauses. So I assign it to my deadbeat brother. Sorry, deadbeat brother, you're not really a deadbeat. I assign it to my deadbeat brother and he doesn't qualify for the loan, and we use the financing contingency to get out of the deal that I couldn't have got out of myself, but I assign it to him and he can get out of the deal. And so again, it's a kind of a pseudo loophole. So again, may not assign is your best practice unless there's some reason to do otherwise. If you forget to do anything, it is freely assignable, and that's generally not what you want. Did that answer your question?
I knew that if it were a regular, some family buying a house and they're not going to make it into an LLC, it's not going to be incorporated, but the ones I'm working with are very adamant about it because they are changing it.
Right. Again, if you have a buyer, the reasons to not do it are my crazy example of getting out of a deal, or you got flippers who are buying it and their plan is to flip it. They're going to buy it from you for $100,000 and sell it for $125,000, and they want to be able to assign it, and they're going to charge an assignment fee and be out of the deal, but get paid $25,000 for assigning the contract. And again, you as a seller may not care about that, and you may allow it. But if somebody asks for assignability, as the seller, you should say why. And if the reason is acceptable to you, then let it be assignable. Who cares? But if the reason appears shady or you're concerned about it, then don't. Again, it is a negotiable provision. And if you have a buyer who says, I won't do it without that, again, the question would be why? And the answer might be acceptable and it might not. So I don't want to get all the possibilities there, but.
They can still check may not assign.
Again, there's a couple of different ways. So the question for the Zoom people is, what if you check may not assign and then they want to transfer to an LLC? As I say, a seller can allow it at any time. The fact that it says may not assign, the seller can say, I don't care if you transfer to your LLC. The question becomes, as a title company, I'm preparing a deed. Am I doing the deed to John Lack or to Waterview Title Services LLC? You know, who am I doing the deed to? And if the contract says John, then I'm doing it to John. And if John wants to transfer it to an LLC, that's post-closing, none of my business. Or can we do it in one fell swoop and go straight to the LLC? If the parties don't care, I don't care. But if nobody directs me otherwise, I'm going by the contract. So then I either need an assignment of contract or a written direction, but I do that all the time. A husband buys it in their name, contracts in their name alone, but we want to put husband and wife in title. So I put husband and wife in title. As long as nobody cares, nobody cares. So again, that's the practical reality of it. But if you check may not assign, then the seller's not obligated to do anything other than deed it to the buyer on the contract. Okay, we need to move on. This is the worst part, and usually I take a break before that, but I'm so far behind, and we're not at break time anyway. I'm going to do my best on financing. It is very critically important, obviously, and probably the most important segment to get right. So there's 4 boxes under financing, A, B, C, and D. I tried to squeeze them onto the one page there, but hopefully you can read it better on your real version of the contract. So we'll start with, I'm going to start with C and D because they're quick and easy. So C, all right, I'm going on 5 or 6 years under this lecture now, and I have not been proven right yet. But I'm going to stand firm and say that sometime in the future, we are going to see assumptions of existing mortgages. I have not seen them in 30 years. I used to see them all the time in the 90s. It was not uncommon to do assumptions in the early 90s. But then rates went down from the 80s, and they've steadily come down for 20 plus years. And so you don't see assumptions because anybody getting a mortgage can usually get a better mortgage than their seller had. That is absolutely, positively, definitely going to change at some point. I've been closing loans in the 2s, mostly 3s, but in the 2s, and there's just no way it's going down from there. And at some point, I don't know when, because I keep guessing wrong, but at some point it's going to go up. And there's a lot of FHA and VA loans out there that are assumable. And 5, 6, 7 years, whenever it is in the future, sorry, Zoomers that I banged that, the rates are going to go up at some point. And even if they only go to 4 or 5 or 6, somebody with a 2 or 3% loan, that an assumable loan is very valuable. So if and when this day comes, remember that I said it 15 times first, and you'll check box C. And if you do, there's a rider for it, and there's a lot of issues with assumption. I'm not going to discuss them now because it's not relevant today, but someday it will be, so keep that in mind. D is purchase money note mortgage. That's when the seller is lending the money to the buyer. And you'll see there it says see rider's addenda or special clauses for terms. My biggest note there is if the seller is going to be the lender, again, whether you see me or another attorney, have the seller get an attorney because the seller just became a lender. And you know Bank of America has attorneys, you know Wells Fargo has attorneys. Your seller who just became a lender should have somebody preparing their legal documents that protect the loan that they're making. The buyer doesn't pay, the seller needs to be able to foreclose. They need to have properly drafted documents that protect them. Sure, it's important to the buyer that they sign acceptable documents, but the seller is the one who has to foreclose if they don't get paid, and as long as the buyer pays, everybody's happy. So it is very important. Plus, the preparation of the promissory note and mortgage is legal work. There is an exclusion for title companies that don't have an attorney. Title companies can prepare a mortgage because they're insuring it, but title companies are not excluded in the unlicensed practice of law for preparing a promissory note. They do it. They're not supposed to unless they have an attorney, but The best practice, your seller has become a lender, lenders have attorneys, they should get an attorney to represent them to make sure their documents are acceptable. That's,
If the seller's not an agent,
okay, I'm not sure I understand what you're saying, but again, yeah, I don't understand the statement.
the seller becomes,
Right.
and how can he write a contract if he's not?
No, okay, so the question, when I say the seller becomes the lender, I mean that if you check paragraph D, the seller is now lending the money to the buyer, but somebody needs to prepare the legal documents, and it can't be.
It's not a choice, is it?
Well, okay, again, I don't want to get too far afield here. A person can prepare their own legal documents. Just as an aside, the unlicensed practice of law means you, as a non-attorney agent, can't prepare a legal document for me, your client, to sign because you're not an attorney. If I, forgetting that I'm an attorney here, if I want to prepare my own contract, I'm allowed to do so. The law does not prevent people from entering into their own agreement. But again, yes, that'd be foolish. A seller preparing their own promissory note and mortgage, legally a seller could do it, but that'd be absurd. And an agent can't do it. And title companies do it on behalf of the transaction. Technically, they're not supposed to prepare a promissory note. But again, that's a far afield. So my point on paragraph D is get somebody who knows what they're doing to draft the paperwork properly, but make sure, again, scaling back to my job here to teach you how to prepare the contract, when you check paragraph D, you need to either, there is a seller financing rider, I use it all the time, and it's a perfectly fine rider, just make sure you fill in the blanks properly, or you can use the special clauses, and you don't have to use the financing rider, you can use the special clauses that say, you know, $100,000 mortgage at 10%, for 10 years, amortized over 30 years with a balloon, blah, 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 you know, but make sure the terms are clear. And again, there's more to it than you might think, which is why I recommend an attorney be involved. But that said, if you do the seller financing, use the rider, fill in the blanks. Now we're going to go back up to A, which is the best, cash. Yay, we love cash. Cash doesn't really mean that it has to be cash. It just means that there's no financing contingency and there's no CFPB, the Consumer Finance Protection Bureau provisions. So a buyer who wants to get a loan can still check box A, but then they won't have any contingencies. And if they don't get the loan, they still have to buy the property. So basically a buyer is saying, I have the money, I have the ability to buy the property. I might choose to borrow it from another source because it's a financially wise move. I can borrow it at 2% and I'm investing at 5%. So yeah, I'm going to borrow the money, but this deal is not contingent upon my ability to borrow the money, and the lender, if they don't give me my closing disclosures in time, I don't get to extend the contract in that paragraph 5 we talked about. So that's the relevance of it, but it does not prohibit a borrower from getting financing, which they reworded this, and I'm very glad they did, back in, you know, the 04 and 07 contracts. It didn't read that way. And you'd have sellers say, you're not allowed to borrow money. And I'm like, yeah, I'm allowed to borrow it as long as I give you cash at the table. What do you care? And it created issues. So they've eliminated that misunderstanding. It is not that you have to come to the table with your own cash. It's that you have to come to the table with the money to close. And if you don't, you have no contingency. So that's A. That's the easy one. Now we get onto the hard one, B. And this is where I'll go as quick as I can, but I have to spend time. So one other note, you must check a box, and it says it on here too. So if you read this little article, it says so. Don't not check a box. If you don't check A, B, C, or D, even if you fill in all the terms of B, so obviously you must think B applies because you put in, you know, the dates and all of that. If you don't check the box, you didn't activate the paragraph, and we have ourselves an argument, and I don't know how the argument would play out. I don't want to find out. Check the appropriate box. So the box for B basically says the contract is contingent upon the buyer obtaining a loan. Most people who want to buy a house need a loan to get it. So I love your home. I want to buy your home. I'm willing to pay what you're asking for it, but I can only do so if Bank of America is going to lend me the money, or some lender. And if they don't lend me the money, as much as I love your home, I can't afford to buy it. So here's my deposit. I'm going to use my due diligent effort. I'm going to try to get a loan. If I cannot get the loan, then as long as I tried, I get my money back. So again, the deposit's not at risk. If the contingency fails, the buyer does get their money back, but the buyer has to jump through the hoops attempting to get the loan. So it's very important that you fill in the terms. There are blanks, and it's okay to leave the blanks. I personally usually put don't leave the blanks, but we already discussed that. So A, check the box. B, if it's contingent on financing. Next, is it going to be conventional financing, FHA, VA, or other? Other could be private lender or something like that. But check, if they're going for FHA or VA financing, then there is a rider that is mandatory. I think it's mandatory, but I'm going to say it's mandatory that you have the FHA or VA rider because it has additional clauses in it. So if you're doing FHA or VA financing and you check the box, make sure you include the FHA or VA rider. If it's conventional financing, great. Then loan within blank. So the current version of this contract is 30 days, which is enough time for a diligent borrower to get approved or denied for a loan. Can they need more time? It could happen. And again, if you have a buyer who needs more time and you need to put 40 or 45 or some other date, do it, but be prepared to explain to the seller why you're extending it. Now you get a seller who says, I only want to wait 20 days for financing. Make sure you've talked to your loan officer and make sure you're prepared, because if you don't get the financing, you either have to cancel the contract, even though you've put in all this effort to get it, or get an extension. So my experience is 3 weeks, 21 days, 20 days maybe, but you'll have brokers tell you, I can do it in 14 days. I don't want to say don't believe them, but contractually, I don't believe them. Contractually, give yourself at least a minimum of 21 days, and 30 is the norm. And again, unless there's a reason to change that, don't. But again, if there's a reason, it's okay as long as you can explain it. That's the loan approval period. And then fixed, you check the box for a fixed loan, adjustable loan, or either. And again, there's no default on that, so check a box. If the buyer doesn't care if it's fixed or adjustable, great. Most people want a fixed rate loan, and that's probably the most common box to check. I've never known anybody who insisted on an adjustable rate loan, but again, theoretically, you could check that box. And then at an interest rate not to receive. Now, they changed this, thankfully, a few years ago. As an attorney for many years, I put PREV, which stood for prevailing rates, and now they've hard-coded it into the contract, so I don't have to put it. And so the buyer is subject to getting a loan. Again, we talked about C paragraph 2C. That's why it's so important to put the dollar amount in paragraph 2C, dollar amount or percentage. But you do need to have that blank filled in. I've had contracts where paragraph B is checked, but 2C is blank. Again, we end up in an argument over were they getting financing or not. Do they get their money back for applying for a zero loan? I'll give them a zero loan. If you forget to put something in 2C, then they've agreed to apply for a loan for zero. I'll give it to them. That's great. They can't get out of the deal. So again, 2C is a very important line if you're going with 8B. Prevailing rates, again, so prevailing rates is based on buyer's credit worthiness. That might not be the best way to go. That's what we want as a seller. That's fine. In other words, if you get approved for a loan, we don't care what your interest rate is. If you get approved, you're bound. As a buyer, know your buyer and know their financial limitations. If the most the buyer can afford is a 5% loan, they've done the math, they know what their PITI is going to be, the max they can afford is 5%, but their credit stinks, but some lender will give them a loan at 6% anyway. If you left it at prevailing rates and they get approved for a 6% loan, they're going to be contractually obligated to accept it. And yet they're going to be in foreclosure in a couple of months because they can't afford it. So if you have a buyer who knows what their limitations are, put the number in, whether it's 3 or 4 or 5 or 6 or whatever it is, put it in. Now, again, the generic comment is, as a buyer, the lower number you put, the better, because you can accept This is a buyer's contingency. The buyer has the right to get out of the deal if they don't get a loan on these terms. If they accept a loan on different terms, they're allowed to do so. The seller can't say, no, you can't take that 8% loan. Seller has no say in this. If the buyer can waive the contingency, they can do anything they want. There's a buyer protection clause. So the lower the number, the more out the buyer has. The higher the number, the safer it is for the seller, thus the term prevailing rates. But again, if you're a seller and a buyer presents you with a contract that says 2%, don't take it, because they're not likely to get 2% anymore. The market's not at 2%. So it's basically, they'll jump through the hoops, they'll not get it. They're basically buying themselves an out clause. So, but again, if they want 4%, and you want 5%, you negotiate it, or you do what you need to. So again, be aware of that, and either leave it blank or put in a number that protects your client, so to speak. So buyer shall make, this is again another one of those clauses that I have nailed people on. Buyer shall make loan application. They have to apply for the loan, not a pre-approval. They have to make loan application. Again, there are legal fights over what constitutes loan application. So in my opinion, if you submit a 1003 to a lender, you've made application. Much less than that, it's going to be a harder argument. But loan application within blank days, 5 if left blank. So if you sign the contract, your effective date is today, you got 5 days, which if it ends on a Saturday, Sunday holiday, it'll expend the next business day, but you got 5 days to make loan application. If you know you're signing the contract and then going on a 7-day cruise, then put 10 days in there, or put something, say, look, I'm going to apply. Don't worry, I'll get approved, but I need 10 days because I'm going out of town. If you don't make application within the time frame it says on there, time is of the essence. It's an essential provision of the contract. If you leave it blank and it's 5 days and they make loan application on day 6, they get turned down for the loan. They come back and say, oh, bummer, we didn't get our loan. We want our deposit back. I get hired by the seller. I find out you applied on day 6. I'm going to say that clause expired on day 5. You lost your financing contingency because you didn't apply in a timely fashion. So that clause is expunged and I'm keeping your deposit. And I'll probably win, or truth be told, we'll negotiate and we'll keep half of your deposit. But bottom line is that missed date is a default and it waives the contingency. So make sure you're clear on the date you put in. If you leave it blank, that's fine. Make sure your buyer applies for the loan within the 5 days. Now, going back to paragraph 2C, they must apply for the loan on paragraph 2C. If they put 80% financing, but your borrower really wants 90% financing, it's okay. They can get 90%, they can get 100%. We don't care what they accept. But if they only apply for 90% financing because that's what they want, and the contract called for 80% financing, but they never made application for 80% financing, they get turned down for the 90% financing. I, as the seller's attorney, are going to say you never applied for the loan you were supposed to apply for. I'm keeping your deposit. So apply for both. Go to your loan officer and say, hey, look, contract says 80, put my loan and application in for 80, but see if you can get me 90 also. Perfectly okay. You're allowed to get as much as they'll give you, but make sure you apply for the loan that this paragraph describes, whether it's FHA, VA, conventional, adjustable fixed, and whatever the percentage. But make sure they make the application. This clause is going to control whether the buyer gets their deposit back or not to some degree. Then, again, time is not permitting for me to go over all of the details here, so I will just have to tell you guys to read it on your own, but I'll point out a few of the highlights. I feel obligated to do that. So if the buyer gets loan approval, they're supposed to notify you in writing. That rarely happens. But if the buyer doesn't get loan approval, after the exercise of diligent effort, then anytime prior to the expiration of the loan approval period, they can send a written notice saying, I didn't get approved, and I'm either A, waiving the loan approval, I'm going to go ahead with it anyway, I'll find the money, or B, I'm canceling the contract. So they do have a choice. Again, it's the buyer's option to either waive it or not. But I'll give it a minute. but they have to do it before the expiration of the loan approval period. If the loan approval period expires and they haven't delivered that timely notice, then the loan approval is deemed, I think it's on, yeah, well, I'll have to find the clause, but basically it's deemed to be approved. So if you don't terminate, the burden is on the buyer. If you get loan approval, good for you. If you don't get loan approval, you need to either terminate it or waive it. But if you do nothing, it's the equivalent of waiving the contingency. It's deemed loan approval, and you won't get your deposit back after that. So you need to cancel. That's why I say the 20 days isn't great, because if they haven't gotten the loan approval yet, they need to cancel the contract. Or again, of course, you negotiate an extension and you say, we need a little more time to get the financing contingency, and it's not a big deal. There's a form to extend the financing contingency, but it is an additional step, an additional negotiation, and the seller could say, no, I won't give it to you. Then you have to terminate the contract, and all that time was lost. So very important. Now, if the buyer doesn't get loan approval, the seller has, it's weird, but the seller has a 3-day window to terminate the deal. So the buyer's loan had 30 days, didn't get loan approval, didn't terminate the contract. Now it stays 31, 32, and 33. The seller can say, you know what? I'm terminating the contract. You didn't get loan approval. I'm out of here. I'm selling it to somebody else or not selling it. But if the seller doesn't do it within those 3 days, then we're back to an enforceable contract on both sides with no financing contingency, because the loan approval is deemed approved. So again, it's a weird little 3-day window for the seller to cancel. Otherwise, both parties are still bound. So if loan approval has been obtained or deemed to be obtained and we don't close, then the seller keeps the deposit unless, so many little provisions, us attorneys, seller defaults. So if the seller defaults, the buyer gets their deposit back. Or you got a loan approval, but there's property related conditions such as it needs a new roof or something of that effect, then if we don't deal with that, then the buyer can get the deposit back. And then the third one is what I call a pseudo appraisal contingency. If they get a loan approval subject to an appraisal and it doesn't appraise for enough for the loan, then the buyer can get their money back. But the reason I call it a pseudo appraisal contingency, my example, $100,000 property, $50,000 loan. It only appraises for $80,000, but the lender says, we're good with that. We'll lend you $50,000 on an $80,000 property, even though you're paying $100,000. Buyer can't get out. Buyer's got to the buyer's got to buy it for $100,000, and they're just overpaying for the property, and that's their contractual obligation. It more commonly is an 80% financing, and if it doesn't appraise for $100,000, they're not going to get the loan. So it is kind of an appraisal contingency, but there are scenarios where the lender would lend even though it appraised less than the contract price. So if you want a true appraisal contingency, there is a rider that's a true appraisal contingency. Okay, I think I covered everything there. Yes, sir. Did you have a question?
On the handwriting part, email or text message, would that be handwriting if the buyer was like, hey, I don't want to?
The termination? Okay. I mean, if they truly are going to terminate, then I think I'd use the release and cancellation form, and again, send it along with the email. We failed to obtain our loan approval. Attached, please find a release and cancellation, and see what happens. Then they hire me to try to keep the deposit, and then I dig in to see if you really applied in a timely fashion. Did you use due diligent effort, or did you get a friend to write a turn down letter? You know, those kind of things. So again, I do play bad guy to buyers trying to get out of a deal. If they've done everything they're supposed to, then I'm not a problem. But if I find that they were not doing what they're supposed to, then I'm going to try to keep the deposit. So that's why it's important. But as far as documenting it, an email would suffice, or any form of written communication saying I did not get my loan approval, I want my deposit back. Yeah. Okay. Sorry, Zoom, I forgot to repeat the question, but hopefully the answer gave you the question at the same time. All right, so made it through financing. Where are we on time? Are you guys okay with not taking a break? Okay, good, because there's no way I make it through otherwise. So, all right, I got 1 hour to get through the rest of this contract, and usually I'm on page 4 by now. I'm only on page 3. So Closing costs, again, really exciting slide there. Seller's cost, buyer's cost, look at that. So again, the contract is hard-coded to include those fees that are typically paid by a seller and those which are typically paid by a buyer. This is negotiable. You can put in the right, in the additional clauses that the buyer will pay all closing costs or the seller will pay all closing costs. Or we go back to actually that paragraph 2D, other, you can put a credit, seller closing cost credit, that can go on 2D, other, or you can put it under the special clauses, seller will give a 2% credit or whatever. There's a variety of why. Again, as long as it's clear and unambiguous what you're doing, it doesn't matter exactly how you do it. But if you didn't do anything and we went with the defaults, paragraph A and B set forth what the defaults are. The more important one is paragraph C. And again, interestingly, this article mentioned what I'm about to discuss, paragraph C, but it goes on to say if you don't check a box, you have a question as to the binding nature of the meeting of the minds. Do we actually have a contract if you don't check a box? And there is no default. In my lecture, I argue that if you didn't check a box and you were in front of a judge, I'd like to think the customs of the county would control, but if I'm on the other side arguing, I'd say we never had a meeting of the minds, the heck with the customs of the county. So this article is correct. Check your box. Now, the box you check in Brevard County, the custom is 1, which is the seller designates the closing agent, pays for the title policy. That is negotiable. Again, I'm me. I have a title company. When I buy a property, I usually want to do my own title work. So I would check paragraph 2, and I would probably offer a slightly reduced offering price offset by, look, it's going to cost $2,000 for title insurance. I'm offering you $98,000 instead of $100,000, but I'm paying for the title insurance. So you're getting $100,000. And the only reason I'm doing it that way is because I'll pay less for title since it's my company. So most people don't have a problem with that. And that's how I've purchased property. But again, I have clients who are loyal to me who say, I want you doing the deal no matter what. I usually try to make the seller in Brevard County still pay for it because that's the custom and I handle it because my client wants me to. But every once in a while, the buyer will say, look, I'd rather pay for it and have you do it than let somebody else. Again, personally, I love that, but I also understand that all of the title companies in the area that are competent, and most of them are, I work with a lot of title companies when I'm an attorney, and there's very good ones in this county. So it doesn't matter to me who the title company is, again, as long as they're not one of the very few who are not competent. So the seller pays, the standard phrase is he who pays picks. So the custom is for the seller to pay and seller to pick in Brevard County. In Broward and Dade County, you see they actually have their own separate provision. That's where the seller pays for the abstract or the title search, which is usually a couple $100, and it even says there, if left blank, a couple $100, and the buyer pays for the actual premium. But usually, again, in Brevard County, you'll check paragraph 1. So it is negotiable. He who pays usually picks, but you can do what you do there. The other blank is at the top, line 145, 15 or 5 if it's a cash deal. I've been putting in 5, 10, or 15, depending on my mood, really, and how busy I am, if I'm the one doing the title work. But the idea there, and again, it is a time is of the essence. The title company is supposed to deliver, again, whoever's providing it, doesn't matter. The title company is supposed to deliver a title insurance commitment to the buyer so that the buyer has an opportunity to review it. I don't think it's the next slide now. So I don't, the review provisions are in the standards, which I might have a slide on, but I'm not gonna have time to go over the standards very much, but I'm gonna tell you where to look. Paragraph 18A, and then it's 1, 2, and 3 are the standards for title exam. And the buyer has 5 days from receipt, and this is important. It's on line 374 in the contract. Buyer shall have 5 days after receipt of the title commitment to examine it to make sure title is acceptable. Now, again, you guys, I don't mean you personally, and I don't mean to disparage anybody, but it's very frequent that you'll be good about making sure you get the title commitment, but does anybody actually look at them? And I do teach a class on how to read a title commitment. It is important to look at the title commitment, not just to receive it. The buyer has 5 days to object to title if there is something in there that's objectionable. And when I represent buyers as an attorney, I actually read the title commitment and I read the exceptions and I make sure they're not objectionable. And it's not uncommon for me to tell the title company they have to remove an exception. Usually it's because it's some old expired thing and it's just been carried on over the years and I'm just trying to clean things up. But every once in a while, there's something that's actually objectionable. But you only have 5 days to object. If you don't object within 5 days, you're accepting title as is. And so it is, again, important to both receive it per line 145 and then review it per line 375. So again, I put that out there. As far as filling in the contract, it's okay to leave the blanks or put in a number if you want, but I think I'd leave it blank if I'm you guys, because you're not the title company, and let the title company deal with the date. Any questions on that? Good. Looking down, nothing there. Okay, so continuing on with the cost provisions, the survey, I will tell you, if there is a financing, a lender is going, they will tell you we don't require a survey, but what they do is they require the title company to issue title insurance without a survey exception. Well, the only way I can issue a title policy without an exception for a survey is if I have a survey to review and determine if there's any encroachments of easements and things like that. So there's what's called the standard survey exception, which says any matters that would appear on a survey. The lenders make me delete the standard exception, and I can only do so if I have a survey. So in a roundabout way, if you're getting a loan, you got to get a survey. And I recommend it anyway. I have buyers, cash buyers, I say, get a survey. You're paying $100,000, $200,000, $500,000 for a property. Surveys cost about $300, sometimes a little more, but around $300. And they show you the physical layout of the building on the land, and they show you whether your pool encroaches into the neighbor's yard or the fences or the sheds or all of that. Usually it's not a big deal, and rarely do you have a major survey problem. But when you have a survey problem, they're often major. The house was actually built over the property line, and now you have to tear down your house because the neighbor wants it off their lawn. You know, I mean, there can be survey problems, can be substantive, and the only way to know is to get a survey. Now, often a seller will have a survey, and if it's recent enough and they can sign a sworn statement that they've made no changes to the property, as a title company, I can delete the survey exception and everybody's happy. We save $300 and we use an old survey. If it turns out the surveyor was wrong, the buyer can't sue the surveyor because the buyer didn't pay the surveyor for the survey. So the buyer is not protected by a bad survey. Now, again, the title might come into play, so I don't want to get into all the liabilities. But again, I'm a fan of spending the few extra bucks and getting a new survey. Again, if it's from last year and nothing's happened, sure, you can use an old survey. But I have people come to me with surveys from the 90s and say, can we use this? And technically, I'm not supposed to go older than, some say 10 years, some say 20. Again, if I know the parties, I might extend my authorization, but best practice, get a new one to make sure that the neighbor didn't. You know, the seller is signing a sworn statement. He didn't put up a fence, but he didn't say that the neighbor didn't put a shed and they misfired on it. So again, good practice, get a survey. Home warranty, good sales pitch. A lot of sellers are providing them. Again, interestingly, that was part of this article as well. If you're not doing it, check the NA box so that we know that there's no survey. Home warranty, if it's left blank, it's left blank. The interesting story in this article was they checked seller and they put the dollar amount, but they didn't say who it was issued by. And the argument was the buyer wanted it from this company and the seller wanted it from this cheaper company. And that's what this little article, mentioned. So interesting. Again, usually it's not applicable in my world, but if you guys are providing them, then there's not, again, it is a good sales pitch. So maybe do it. Special assessments. The default is paragraph 2A, FA. And I agree with that default, but if I'm representing the buyer, I check B. If I'm representing the seller, I check A. I rarely advise the other side. If it's sent to me one way and I want it the other way, I rarely change it, but what I do is I check. Are there any special assessments? Because the real issue here is, are there special assessments that we're going to get stuck paying for? So now I explain what they are. This is not condominium or homeowners association assessments. This is governing body special assessments. The example I give, street lighting improvement districts. So we've decided to come through your neighborhood and put street lights up, and they're going to charge everybody $10,000 to have street lights in the neighborhood, but they're going to make it payable $1,000 a year for 10 years. It's going to be on your tax bill. So it's now year 3. So there's still $7,000 left on this assessment. If we check box A, we're all good. We prorate the taxes, we prorate the assessments, the buyer starts paying, and they pay the taxes every year, and we're good to go. If we check box B, and I do the title work, and I see the special assessment, even though it's included in the tax bill, it was a special assessment for $10,000, we've only paid $3,000, I'm hitting the seller up for $7,000, and all of a sudden they're really mad because they just paid $7,000 out of their pocket that they didn't know they were paying, because to them, it was just part of their tax bill. And if we had checked box A, it would have cost them nothing. Box B cost them $7,000. Obviously, if I'm on the buyer's side, that's a win. My client just saved $1,000 a year in their taxes. So again, depends on whose side of the table you're on, what you do. Best practice is to find out if there's anything there. It is very uncommon and very rare. They're not, it's not a regular thing, but the example I give, obviously, again, was a live one, and it's a bad thing when it happens and all of a sudden you're collecting $7,000 from a seller. So be aware of it and check the box appropriately. If you don't check it, then it's A, which I think is probably the fairest result, but that's my opinion. All right, any questions there? Good. Okay, now I'm going to really fly through meaningless before we get to the next meaningful. So disclosures are not meaningless, and there's the laundry list to your right of all the different disclosures. Let me grab my notes because there are some I do want to point out. All right, so again, this is a contract, or the parties are signing the contract. By signing the contract, they're agreeing to everything in writing, and like any good attorney, I'm going to tell you, you should read the contract before you sign it. And that's usually my preliminary remarks, and I didn't do it, so I'm going to do it now. How many of you have read through this contract literally start to finish? Good for you. You should do it again. I didn't do it last night. Actually, I kind of did. I skimmed through it. But in the past, I would read through it every time before I come here. Now I've gotten a little lazy. But the reality is, read it start to finish. You might fall asleep. It might take you a couple of days. You might need another cup of coffee. It's boring as heck, but read it, because there are things in here that will surprise you, and you'll be aware of them once you read it, and you won't if you don't. So rate and gas, we're going to disregard for the moment. You can read that. Permits disclosure is the important one in this regard. Line 196, 195, 96. Seller, this is a signed contract, and the seller says, seller does not know of any improvements made to the property which were made without required permits. Okay? If they don't know it, cool, we're good to go. If they do know it, and it turns out to be a problem later, and they sign this without disclosing it, we got fraudulent or misrepresentation, or whatever language I use. I'm not a litigator, but whatever litigation terms I want to go after you for. You lied, seller. You didn't tell us about it, and you knew. Now, there could be questions of proof of knowledge. It was the prior owner who didn't get the permit, and I didn't know they didn't get the permit. All right, then I'm innocent. I didn't know they get the permit, didn't get it, and I just bought it anyway, and I'm not telling you. Well, now I've misrepresented. So again, you should confirm with the seller that they don't know of any unpermitted matters. And if they do, they need to disclose them. So we'll skip mold. Okay, so there is a line 210, has a blank on it. 20 days if left blank. Again, this is one of those where it's never in my practice come to pass, but this would be where flood insurance, you're in a flood zone, but flood insurance is not available through the National Flood Insurance Program or something to that effect. If you can't get flood insurance, then you can get out of the deal. But I've not ever come across one where you're in a flood zone and you can't get flood insurance. But this gives you 20 days to get out of the deal if left blank. When I remember and when I do it intently, I usually make that number match the inspection clause. I figure if you're doing your inspections, you should check on your flood insurance at the same time and either cancel or not. But the truth is, even if I leave it blank, I've never, ever seen that 20 days be relevant. But it's there, so I tell you about it. Energy saving, energy brochure. Okay, how many of you give that when you do the contract? All right, good for you who do. I'm going to confess off record, anybody watching on record, this is off record. I don't always do the energy brochure, but the buyer, by signing this document, is acknowledging receipt of it. So they can't say they didn't get it, because whether they got it or not, they've acknowledged receipt. So again, one of those things. So lead-based paint, it's mandatory. It's not optional. If the house was built pre-1978, by law, you must give lead-based paint disclosure. That is the most annoying rider in all of the contract. There's a ton of little initial spots. The realtors have to sign it. You have to check boxes. It's hard to do digitally because you have to either give them the authority to check the box or you got to check it for them. Really annoying form. Legally mandated. If it's pre-1978, you got to have the lead-based paint rider. Likewise, the HOA rider, I'm going to discuss that ever so briefly at the very end of this, but it's mandatory. If it's in a homeowners association, not a condominium association, which is also mandatory, but if it's in a homeowners association, you must give the HOA disclosure. And if you don't do it, it's a loophole. So again, we'll close that loophole at the end here, but give that. FIRPTA is Foreign Investment in Real Property Tax Act. If you have a seller who is a non-US citizen, then they're bound by FIRPTA and up to 15% withholding from the proceeds. Even if their proceeds, net proceeds don't cover it, they might have to come out of pocket to do it. So again, FIRPTA is a different animal, no time to discuss it here, and it's not contract preparation, but be aware if you have a FIRPTA seller that you're gonna have to address it. Equally important, again, if you want to be a good realtor and you want to help your clients down in the future, if you have what would be a FIRPTA buyer, it's irrelevant. Anybody can buy property in the United States. We have no problem with that. It's when you go to sell it that's an issue. So if you have a foreign buyer, they should at least plan as to whether maybe they should open up a Florida LLC, or maybe they should just, if it's a husband and wife and just the husband is foreigner and the wife's not, maybe just put title in the wife's name, or there's a variety of pre-planning you could do so that when you go to sell the property, you're not subject to FIRPTA. Otherwise, you're subject to it. It's not the end of the world, but you have to deal with it. So, and then lastly, seller's disclosures. Seller knows of no facts materially affecting the value of the property which are not readily observable. And other than that, there's no warranties. It's an as-is contract. We'll get to that in a few seconds. But and then except as disclosed, seller has received no written or verbal notice from any government entity or agency for uncorrected violations. So my handwritten note here that you can't see is confirm that with the seller. Confirm that they've not received any governmental notices, that they're not subject to any violations. And so material affecting the value of the property and readily observable. So my silly example is if there's a giant hole in this wall, yeah, it affects the value of the property, but there it is. You walked in, you saw the giant hole. I don't have to tell you about it. There it is. If there's a giant hole behind that screen, which maybe let's pretend it's up against the wall, people don't lift off every picture when they go to do their inspections. It's not readily observable if you didn't remove the picture. If I put up a picture to cover a hole and I didn't tell you about it, and then I move out and I take my picture and there's a giant hole in the wall, that's a material misrepresentation. The seller is now, when we do the walkthrough and there's a giant hole in the wall, they can't say, oh, that was there. Well, it might have been there, but we didn't know it, you didn't tell us. So again, silly examples, but seller needs to disclose those facts. If you know about a septic tank problem, it's not necessarily readily observable. You got to tell them about it. If you don't know it, you don't know it. And again, it might be a problem and the inspector might find it, but it's not a misrepresentation. You don't have to tell stuff you don't know. You do have to tell stuff you do know. That's not readily observable. Okay, so that's the disclosures, maintenance and inspection. So this is the last truly important thing, but I'm okay on time. I'm not really, but that's okay. Property inspections and maintenance. So we're going to jump to 12. This is thankfully for this class, we're using the as-is contract, because the standard contract, which was the norm, I'll give you a very brief history. It used to be the FAR-BAR contract was the normal contract that everybody used. And in the normal FAR-BAR contract, there were inspection provisions and there were mandatory repair provisions, and they had dollar limitations. The default was 1.5% of the purchase price. And if the buyer went into inspections, the seller was contractually obligated to repair things up to the repair limit. In 2003-04, the market went like it is now. where it just got insane and sellers could sell properties within minutes like we are now. And so they said, oh, I ain't repairing nothing, it's as is. And somehow there was this conversion where we started all using, first we started using the rider, there's an as is rider, and then they said, let's just go with the as is contract. And so now we all use the as is contract. And that ran through 3, 4, 5 with the seller's market. Then we had the collapse of the market and everything was a short sale. It was as is by necessity. The sellers had no money. They were upside down on the property. The buyer had no choice but to buy it as is. And often that was terrible. I mean, the condition of the property was often bad, but it was an as is purchase and usually lower price because of the short sales and such. We've somehow come out of both of those markets, but we've maintained the as is contract. Good news for me, it's an extra 2 pages of conversation, and there's a whole lot of information that I used to have to teach in paragraph 12 that I don't have to teach anymore. All I got to tell you is that date is critical, the inspection period. The default is 15 days. That's fine. Again, it's negotiable. 7 days, 10 days, 15. Sometimes people want more. You need to explain. Again, like I've said all along, explain to your seller when you're making an offer why you need 20 days, if that's what it is. And when the seller says, I want 7 and you say, I need 10, explain why you need 10 because the inspectors are so busy, I won't be able to get a report back in time. I need 10. I'll order it right away, but it might take 10 days. So again, it doesn't matter. What matters is that's a complete out clause. It's an app. Again, we go back to that language, the sole discretion, line 251. If buyer determines in buyer's sole discretion that the property is not acceptable, buyer may terminate the contract. So I love the house. It's wonderful. The inspection was pristine. But as I'm walking out the door, I trip. And I say, oh my goodness, this house has bad mojo. It tripped me on the way out the door. And I sneezed. Oh my goodness, I sneezed. I'm not buying this house. And I have the right to cancel in my sole and absolute discretion. I don't need a legitimate excuse. I can cancel for 10 days, well, 15, that's the default. So I got 15 days to cancel. On day 16, I got no more right to cancel. The roof could cave in, again, unless it happened after the, forget the possibility of a storm after the fact or something. But no matter how bad the house is on day 16, I'm bound by the contract. On day 15, I can get out for no reason whatsoever. So I didn't get to discuss it too much, but on the additional deposit, we talked about maybe waiting till after the inspection. Very important there. If this is 15 days, make the additional deposit 16 days or 17 days. Don't make it 15 days because now your deposit's due on the same day the inspection period ends. And again, you can cancel. If you cancel before the deposit, you're okay. But if you make the deposit, you need to make the deposit. Again, it's a timing thing. Don't do a 10-day and have a 15-day cancellation. What's the point? So again, I would usually make sure the additional deposit's 1 day after the inspection period if that was my reasoning for doing it. So I digressed. I come back here. Very important. You know the date and you cancel. Now, again, one of those little tricky things that is not socially friendly or whatever, but will happen. You'll have a buyer and seller negotiating repairs. Okay, step back. Seller has no obligation to make any repairs whatsoever. This is an as-is contract. The buyer has the right to cancel, but that's their sole right. They can't say, you have to fix this. No, I don't have to fix it. Now, I may negotiate with you and agree to give you a credit or agree to fix the air conditioner or whatever, because I know if you don't buy it, the next guy's going to have the same problem. I might as well fix the air for you, a bird in the hand, and let's go. But I don't have to. And your only right as a buyer is to cancel the contract. You either accept it or you cancel it. Now we can negotiate, and if we agree, good for us. But if we don't agree, you either accept it or you cancel it. Now, here's I won't call it unethical. It's the questionable behavior. We're negotiating on day 15, and I drag you out till midnight. And then I say, never mind, I'm not fixing anything. You, in good faith, thought, hey, we're negotiating. He's going to take care of it. He wanted $3,000. I wanted $1,000. We'll settle at $2,000. But we never settle. We never sign anything. The inspection period expires. The seller, who never signed anything, no longer has to sign anything. And the buyer has lost the right to cancel, so they've accepted it as is. So understand when you're in those last-minute negotiations, either get an extension of the inspection period. That's the best way to handle it. Hey, look, we're still negotiating. give us an extra few days and we'll either take it or we won't, but we'll negotiate through this, or cancel because otherwise you're buying, or realize you're buying it as is, but understand it's a hard line. And if the seller is jerking you around to get you past that hard line, go into it with your eyes open. Either accept it as is, ask for an extension, or cancel the contract. But if you do nothing, you've accepted it as is. So that's that. So the walkthrough inspection is solely, again, line 266, solely to confirm that paragraph 11. If you jump up to paragraph 11, except ordinary wear and tear, they're going to maintain the property, the pool, the lawn, all of that. So if the pool is green when I sign the contract, then it's allowed to be green when I sell it. But if the pool is nice and blue when I sign the contract, it needs to be blue when we go to closing. So the walkthrough is that they've maintained the property in the condition it was in at the time of the contract. So the lawn has been mowed, the pool is blue, et cetera, et cetera. It is not about new items that have broken or new items that you found. Now, the question for which I don't have an answer is kind of obvious, and I don't have an answer, is let's say the AC breaks after the inspection period and before the closing. I don't know, because the contract was as is, and the question, usually when that happens, sellers step up and we deal with it, and it's not usually a problem. Thankfully, it's rarely happened to me, but usually if it breaks the day after closing, too bad for you. I mean, bad luck. If it died, it died after closing. If it dies before closing, it's one of those questionable ones, but it is an as-is contract, and it is not a maintenance of equipment, it's a maintenance of lawn and things of that nature. So again, there could be an argument on something, but for the most part, be aware that after that inspection period, it's as is, and the walkthrough is just to make sure it's been maintained. Now again, it's as is, so the seller has no obligation to do anything, but line 272, seller will cooperate, that's actually so will cooperate in good faith if they need to obtain repairs or if there's permitting issues. So if there's any outstanding permits or things like that, or any problems, while the seller's not obligated contractually to deal with it, they are obligated to cooperate, because the seller might be the one who has to sign off on a permit for the buyer to get it resolved. But the seller, line 276, is not required to expend any money. So that's that provision. All right, that covers that. Now, where am I on time? 30 minutes to get through lots of stuff. But, okay, so I'm going to, again, I keep saying this, I'm going to attempt to speed it up. I'll do the best I can. Most of the next few pages have no contract preparation. I use app files. I don't know how many of you use app files, but app files gives you 5 pages at a time, and then you have to go to next to get the next 5 pages. I do the first 5, and then I jump to the last 5 because the middle 5, which is what we're about to go over, have no blanks. So again, in app files, you do the first and the last, and you can skip the middle. I often actually scroll through it because, again, that's who I am. But there's nothing there. I don't know why I do it. I just do. But in your case, I'm going to quickly point out some highlights, good and bad, in the terms of the contract, but they have nothing to do with contract preparation. It's just contract knowledge so that you're all better realtors for it is my goal. So escrow agent, I already talked to you. I don't care who the escrow agent is as long as they're reputable. There is a difference if it's a broker versus a title company or attorney. Brokers are governed under the FREC rules, line 293, chapter 475. And I find it more cumbersome when a broker is the escrow agent because they're bound by these rules, which require them to submit an escrow disbursement, a dispute order. I forget the exact phrase, it's probably in there, but they have to do it within 10 days. So it limits the ability of the parties to try to negotiate a settlement. It forces them into an administrative procedure to reach a settlement. But that's fine if that's the way it goes. If it's a title company or an attorney, they will typically hold on to the money. Now they have the right, again in there, to interplead it, to send the money to the bank, to the court, and say, look, I don't want to deal with this. Judge, here's the money. You deal with it. I'm out. And so that is an attorney title company's right to do that. But much more commonly, we'll just sit on the money until you tell us what to do with it. And it's, in my opinion, better for the parties that the title company, they won't release it until we have an agreement. And if we have to go to court, we can go to court, but we're in control of the process. So I prefer title company attorney over broker, but again, it doesn't really matter. The best clause in the whole contract, line 306, this is for us or I say us as realtors, not me as an attorney, because it would be different. But buyer agrees to rely solely on the seller, professional inspectors, et cetera, for the representations, and it exculpates the broker and agent. So you guys aren't your salesman. So you told them it's the best house on the block, and it turns out it's not the best house on the block. Look at that. You're not liable for that salesmanship. You can't lie, you can't misrepresent something, but you're a salesman. Let them get inspectors, let them look at the property themselves. They can't come back to you and said, it's only a 2-bedroom house. You said it was a 3-bedroom house. All right, well, I made a mistake, but obviously if you walk through it, it's a 2-bedroom house. So again, you're excluded from that liability provided you didn't lie. All right, defaults, again, we hate default, we don't want default. Really kind of unfortunate how weak the contract is for seller default. If a seller defaults, if a seller decides not to sell a property, the buyer has 2 options, and they're exclusive options. They can either sue for specific performance, which is to force the seller to sell the property, or they can demand a refund of their deposit, which obviously they're going to get, plus any actual out-of-pocket costs. They paid for an inspector, they paid for an appraisal, they'll get that money back. They don't get time, they don't get rent, they don't get lost value, any of that. It's literal cost. So it's not a great contract protecting a buyer, but it is what it is. And the specific performance can be valuable, and I actually have a case where there was a super specific performance, and ultimately the initiation of the process convinced the seller to go ahead and sell, and that's great because the seller had decided they didn't want to and they got forced to do it. But much more often than not, if a seller decides not to sell, when a buyer comes to me, I'll either refer them to a litigation attorney if they're destined to go ahead and do that. But otherwise, I say, look, by the time you sue them, the fees and costs and expenses of suing them, it can take anywhere from 6 months to a year. On the fast side, it's going to be 6 months. So I can sue them to sell the house in 6 months. Well, I was buying that house probably because I was moving, and I probably don't want to wait 6 months to buy the house, and maybe even 8 or 10 or 12. So suck it up, find another house, be mad, maybe squeeze the seller for some money on the threat of a suit, make them give you a few $1,000s for your troubles. But usually specific performance is not a great option from a practical perspective for a buyer. So the hope and goal is that the sellers really do want to sell and they go through it. That said, there's the provision there on seller default. On buyer default, it's much easier. The seller gets the deposit. That's why we had that whole deposit lecture. You want to make sure the deposit is enough to protect the seller. If the buyer defaults, the seller's keeping the deposit, and that's their compensation, and that's it. Now, there is a provision for specific performance, but generally, again, it's even harder to sue a buyer to force them to buy the property because, again, if it was a cash deal, you could theoretically do it, but it's just not practical. And of course, in this market, why sue somebody to buy it when you can sell to somebody else anyway? So the market forces play an effect as to whether you file the suit, whether you're going to win it, how long it's going to take. Obviously, during COVID, a suit like that could have taken 2 years. So again, there's all sorts of issues. But the goal is let's keep everybody in line so we don't have a lawsuit. And if you do, those are the provisions. I usually discuss it a little more, but again, time doesn't permit. Did you have a question, sir? Nope. Okay. So we're going to move on. Oh, this is where I cheated. So paragraph 18, A through X, read them. So I'm going to point out I don't have the lines, but you have the contracts there. I already talked about the title standards again. Oh, one of the lines that is important. So it's line 370. In the old version of a contract, there was a blank where line 370 is that says none of the title restrictions prevent the use of the property as blank. Now it reads prevent use of the property for residential purposes, and it's hard coded into line 371. If you are buying a property with the intention of a specific purpose, and my standard example is a duplex. If you're buying a property to use it as a duplex, make sure you put in the special clauses in paragraph 20, property is intended to be a duplex. Again, you'd have to figure out the wording, or I'll tell you the wording later, but that you put in there that the intention is to use it as a duplex, offsetting line 370, because it may be a residential property and the seller may have been using it as a duplex, but it might be an illegal duplex. They might have never done it properly and is not permitted and allowed to be a duplex, and you buy it thinking it's a duplex, and then the county comes through and says you can't do that. The seller had gotten away with it, but you don't get away with it. You don't have a claim against the seller because the contract just says residential purposes. If you're buying it for a gas station or a strip mall or something like that, wrong form of contract, use the commercial contract, not the residential one. But so that's line 370, and it is relevant to contract preparation, so I'm right to bring it up. Then we have title examination. Again, be aware of the 5 days. 5 days from receipt of the title to review it. If your client gets the title and they don't look at it and there's a problem, after the 5 days, they can't object to title anymore. So I've had people who have had title issues. They have no legal objection because it's after the 5 days. So be aware of that. Survey, we're going to skip over. Ingress and egress, confirm it. Again, the contract reads, seller represents that there is ingress and egress. That means you can get to and from the property. It's not landlocked. If it is landlocked, and there are some landlocked properties like in the Grant Valkyria area, then you need to note it and you need to address it, and that's okay. But don't just sign the contract without noting and addressing it, because you have a seller that says there's ingress when there isn't. So confirm that. We already talked about leases. And you'll have to get estoppel letters, et cetera, and they'll assign them at closing. Liens, we'll skip over. Time, we already discussed. Force majeure, we discussed. Marketable title, we're just going to have to trust that it'll happen. Closing is at whoever's paying for the title, it's at the closing agent designated by the person paying for the title. So it's going to always be at Waterview Title Services, or can be conducted remotely. We're doing so much stuff remotely now, so of course that's acceptable as well. Closing documents, we can skip. FinCEN, we can skip. Procedure, escrow, prorations, just be aware, line 486, at closing, you will almost always sign from a title company what's called a reproration agreement, and it's just an agreement between the parties that we base the taxes on last year's taxes because this year's bill hasn't come out yet. If the bill goes up, the seller will pay the increase. If it goes down, they'll refund. That is actually hard-coded into the contract on paragraph K, line 486. A tax proration based on an estimate will be readjusted. This standard K shall survive closing. So legal conversation, when you do a closing, by its very statement, closing, it's done, it's over. The contract is closed, it's gone, we've merged into the transaction. If we've done something at closing that changes the terms of the contract, it doesn't matter. The contract is gone after we've closed unless a clause survives closing. And there's very few that survive closing, but this tax reproration agreement is one of them. So if the seller didn't sign a reproration at the table, like they almost always will through a title company, and the buyer gets a tax bill that's $3,000 more than they were expecting, and they send a letter to the seller, the contract, they could be sued under the contract, if they don't reprorate. So just throw that out there, plus be aware of phrases like this shall survive closing. Access to property to conduct appraisal, inspection, et cetera. Again, this is one of those back in the day when the contract was cash, and I had a deal in that crazy time, a cash deal, and the seller didn't want to let the buyer get a loan. I'm like, you can't stop the buyer from getting a loan. He goes, well, I'm not going to let them appraise the house. You can't stop them from appraising the house. They're allowed to get there to do their inspections. They're allowed to get there to do the survey. They're allowed to get there to do their appraisals, and it's in the contract that allows it. Now, again, they don't get to go every day. You can't say, I want to look at the house. I want to show it to my brother-in-law. I want to show it to my sister. I want to show it to my cousin. It's not one of those open door policies, but you do have to allow them access to do what they need to get through it. Risk of loss, up to 1.5%. Again, this is where if the property is destroyed by fire or hurricane or something like that, the contract provides if it's more up to 1.5%, seller is obligated to make the repairs, notwithstanding it's as is contract. If there's a fire and it's damaged, again, insurance hopefully will fix it and everybody will be happy. But the bottom line is the seller is still bound by the contract up to 1.5%. If the damage exceeds that, then they negotiate. Either party can either get out or go forward. And if we can't get it done prior to closing, there's escrow provision. So again, feel free to read it. It's not contract preparation. 1031 exchanges are a great tax tool for clients, and they're not that big a deal. I just closed a couple of them in the last couple of weeks. If you have 1031 issues, feel free to call me. But again, this just says that the parties will cooperate, so it's no big deal. Paragraph O, hugely important. I got bunches of stars here. I know you can't see them and you at Zoom can't see them, but there are stars on lines 510 to 514. Notice and delivery given by or to the attorney or broker, including the broker's licensee, that's you guys, representing any party, shall be as effective as if given to that party. So when I send you the title commitment, I've given it to the buyer. They have 5 days to review it. You don't deliver it to them. 10 days go by, you end up sending it to them later or whenever you send it to them. It doesn't matter to me, or never. Then there turns out to be a title objection. They don't have an objection because delivery to you constituted delivery to them. So if you're given a notice on behalf of your client, the client is deemed contractually to have received that notice. So make sure you give it. I don't think the guy said it in that excellent class on top 5 reasons realtors get sued. I don't remember if this was one of them, but it would be in my book, is make sure if a notice is given to you, you give it to your client because they got it, whether they got it or not, because you got it. So paragraph O, really, really important. A facsimile or electronic PDF copy of this contract and any signatures are considered for all purposes originals. Electronic signatures are acceptable. So again, faxes count, emails count, all of that stuff is legally binding in today's world. So that's good. Integration modification, this is it. The contract is the contract. All the stuff we talked about beforehand, all the negotiation, it needs to be reduced to writing, and the contract is what's going to control. So when somebody says, you said you were leaving the microwave, and I say, I didn't, again, we have that argument over oven, but that's, again, becomes an issue. Put it in writing if you're planning on it. Waiver, skip. FERPTA, we already kind of touched base on FERPTA. Again, if you have a FERPTA withholding client, be aware of it. Buyer waiver of claims. Again, this is an as-is contract. So provided there's been no misrepresentation, any subsequently discovered problems are the buyer's assumption of risk. So you're waiving claims again, but for fraudulent misrepresentation. All right, so I've caught up to not doing too terribly. Addenda and riders, and it's funny because this happens on a somewhat daily basis, including in a deal on my desk last week. Paragraph 19 are the various addenda. So I didn't give this in my unlicensed practice of law speech as well, but we created the FAR contract so you guys can prepare contracts without committing the unlicensed practice of law. There are a whole bunch of addenda and riders pre-prepared so you can cover 90% of the circumstances you're going to face yourself without having to, prepare legalese. If they don't fit into it, again, have an attorney or somebody available. I realized I'm going ahead. I'll get to that in a moment. But the addenda and rider that are there are paragraph 19, and there's the whole laundry list of them. You have CC, Charlie, for the Miami-Dade County tax special taxing provision disclosure. So only thing different is that one rider. Checking the box does not equal attaching the rider. So just because you check the condominium rider box doesn't mean there's a condominium rider. It means there's supposed to be, but it needs to be prepared, initialed. I think it's initialed, not signed, which is odd, but whatever. It needs to be a part of the contract. The other one that I mentioned that I'm going to try to get to before we're out of time is the homeowners association disclosure. It's mandatory. It has to be part of the contract. Checking the box doesn't satisfy that provision. So again, you read line 569, the following terms are included in the attached addenda. We're just letting you know there's an attachment, but there needs to be an attachment. So again, I overemphasize it because I just got another one today or last week with homeowners association with no rider attached. And it's like, oh, well, we checked the box. No, you got to put the rider there. So anyway, that's that. The riders that I have underlined that are of common importance, the condo and homeowner association rider are mandatory. FHA, VA financing, if it's FHA or VA financing, it's mandatory, put it. Short sale, again, there's an older lecture here. We don't do those as much anymore. But if you're doing a short sale, it's very important for the seller to have the short sale rider because it gives them an out on liability if it's not approved for the short sale. Lead-based paint, if it's pre-1978, is mandatory. And here's one that you're not always doing. If you guys are involved in the transaction or it's an immediate relative, it's your mom or your sister or your spouse, and again, there might be a fine line and call the legal hotline if you want to know where the fine line is drawn. But if you're involved in the transaction, check and add AA, licensee property interest. It's no big deal. It's literally a disclosure. John Lack has an interest in the property as brother of buyer, as spouse, as the buyer, as the seller. It doesn't matter. It's just, that's all it says is I'm the seller and I'm a licensee. It's there because society has decided that you as realtors have a higher level of knowledge than a layperson who is not a licensed real estate agent. And therefore, you might be being unfair to them. If you're the buyer, you're going to check the boxes that are in your best interest, the same as I do as an attorney. I'm going to do everything in my client's best interest. But because you're a licensee and you're involved in the transaction, you need to disclose that. That's all there is to it. But not disclosing it can be a FREC violation. So remember that one and check that box. Any others that are really important? Buyer and seller attorney approval. Again, I'm a fan of being the attorney of a transaction, representing a buyer, but you guys work on the weekends, and when I'm not wearing my realtor hat, I don't. So you're out there on a Saturday signing a contract, and you got a Connecticut buyer who wants an attorney, but he also wants to get the offer in. Say, look, I'm all in. Here's my offer. I just want my attorney to review it. He's not going to get to it till Monday. Check the buyer's attorney approval. Ideally give me 3 days, but 2 days is fine. I'll do it on the weekend if I have to. But check the box. I won't kill a deal. The buyer has agreed to the terms. I'm just making sure there's nothing, special clauses that are bad, that there's no, again, whether we check box A or B on that F and there's a, are we getting stuck with an assessment or not? I might look it up and advise my client, but basically I'm just making sure it was done properly, that you didn't leave any blanks. No, you guys won't because you're here. But if you forgot to check who pays for the title or whether it's assignable or things like that, my job is to be that second set of eyes. So put the buyer's attorney approval or seller's attorney approval if you're doing it on a weekend, and give me a couple of days and I'll look at it quickly. Again, pre and post occupancy, we're opposed to it, but there's a rider if you end up doing it. And that's about it for the most of the stuff. Again, you see other stuff there. Moving on to additional terms. My 2 comments: beware of legalese and be precise, avoid ambiguity, vagueness. When you think something is clear, ask your neighbor, your friend, your broker, make sure it's clear and unambiguous. As an attorney, I can twist just about anything. So you say buyer will give, again, if you say up to 3% in closing costs, there's a whole bunch to unpack in that. Up to 3%, so that means it doesn't mean 3%. It only means up to 3%. So what if the closing costs are not 3%? Good, then we don't have to pay the whole amount. What are closing costs? Does that include prepaid interest, or is that just the title company's closing fee? So there are lots of room for ambiguity. So again, you want to be clear and precise as to exactly what these special terms are. And again, lots of them are easy, and you guys are competent and capable of doing it. And especially if you consult with your broker, you can draft it and it's not a big deal. The minute you go beyond something as simple as 3% closing costs, which is not that simple, call me, call the other attorney you've affiliated with. If you need to, call the title company if they have an attorney on staff, but somehow, obviously speak with your brokers. but don't draft legalese, because I'll get hired after the fact and then I'll pick it apart. And then you may have created, we talked about the liability of a broker. You may have created liability if you've overstepped your bounds and created a poorly drafted addendum or additional terms. But the additional terms are used, you know, for a whole variety of reasons that I don't have time to discuss. Here comes this gentleman's, as far as the offer, counteroffer rejection. You can use, I've never ever seen this used, funnily is probably not a word, but 589 or 591, they either counteroffer and the counteroffer terms, which is what this gentleman talked about earlier about using a counteroffer form, which is great. You check the box, you attach the counteroffer, we sign that, we have a contract. It's a good, clean way of doing it. Alternatively, you go through and you mark up what you don't like and you initial it and you send it back for initials. That's okay too. You can reject the offer by checking 591 and reject it, and that just cuts it off quicker. I don't think I've ever seen somebody check and send back the rejected offer, and that's the end of it. It's not, I mean, it's there, it's good. I just have never seen it done. But if you want to start rejecting offers quickly, check that box and send it back. So that's that line. Signatures, how am I on time? Where's that clock? Okay, 5 minutes, good. So you got to sign it. The authorized signatories for each party. So all of the buyers, whoever the buyers are, need to sign it to be legally bound by it. That's the easier one. Now, of course, if the buyer is an LLC or a company or a trust or something like that, then the person signing has to be authorized to sign for that entity. I don't have time left to go over that, but I will stay after to answer any questions. If you have questions about who's the proper party for an LLC, who's the proper party for a trust, for an estate, all of those things, that, well, estate would be more for seller, same thing applies. If you're a seller, all of the seller is the record owner. We discussed that at the very beginning. Who is authorized to sign on behalf of the record owner? That's who needs to sign, and you want to make sure you get it. I'm a big fan of putting the addresses for purposes of notice there. What I've been doing lately is putting a street address if I have it, putting a phone number and email if I have it. I try to put in all the information because I like the parties to be able to communicate. And again, I'm a title company. I often need to call somebody, so I often put it there just for my own sake. It makes it easier. As realtors, I have found that many realtors don't want to put their client's contact info. They want everything to go through you. I am fine with that. Remember paragraph O, if it's going through you, it's going to them. So make sure you've given any notices I give you to them. But if I need to call you to get the seller's social and you want me to call you instead of them, whatever, or give me the seller's number, however you want to do it. But putting the address there is a convenient way of facilitating communication. Broker. So here, obviously, you put the listing sales associate and the cooperating sales associate. So you got your listing agent and the selling agent, which is really the buyer's agent, which is always very confusing. You can put the name. What I request, I didn't do it here because I think I did this, I didn't do it before CFPB, so I don't know why I didn't do it, but I'm going to do it now. If you don't mind putting your license number next to your name, and if you don't mind putting the brokerage license number, the CQ number, next to the broker, as a title agent, the CFPB, the closing disclosure, requires that we disclose your name, the broker's name, your license, the broker's license, your contact, email, and phone number. That's what I'm required as a title company to put on the closing disclosure that I send to the bank. So I know I can log on to DBPR and pull all of that information, and I do. But it's an extra step for me to have to log on to DBPR and do all that. Sure, it would be nice if you guys just spoon feed it to me right there. Give me your number, your SL or your BK number, and your CQ number, and now I don't have to look anything up. So that's my pitch to you. Please do that, but it's not required. Now, the other thing, and I've discussed this, and some brokers agree, some don't, you can put what the commission is there. You can't negotiate it, and it can't be a part of the terms. You can't offer to seller, hey, as a buyer, I'm going to offer you this, but you only have to pay your realtor 2% instead of 3%, or my realtor 2% instead of 3%. It can't be a negotiation, but as a disclosure, there's no harm in putting what the agreed commission are. Again, and that's for me as a title company. I need to know it to put it on the closing statement. So if you tell it to me on the contract, it makes my life easier, and it's perfectly okay to put it. It just cannot be your listing agreement is what controls what the number is. It can't be a negotiated matter. But with that said, time is not permitting, so I'm almost done. I've got 1 minute, and then I'm gonna have to go a little beyond. If anybody needs to leave, you're welcome to do so. I'm just gonna briefly discuss the Condo and Homeowners Rider, but real quickly to finish this off, it's a legally binding contract. Do not give legal advice. Seek legal counsel if there's any questions. It is true that title companies and realtors can manage transactions without attorneys, and it goes through smoothly all the time. But if there's a question, if there's an issue, don't you step into the role of attorney. At that point, refer them to me or somebody to get counsel, or at least advise them to seek counsel, so it's their call, not yours. And there's a perfectly fine counsel whose name and number you're welcome to give out. Sure.
Since 2008, what peace of mind, you know you have a professional working with you, and ethical professional that is, I mean, if you choose one, I started with, actually I had a buyer that the seller had chosen them. That's how I first ended up there. He was the title company because I didn't even know him. Went there, and all of his different ways of helping you, obviously super knowledgeable. I would be out, if you have to listen, don't title company anymore, realtors, lawyer. In every way, he's great. I just want to say, I got out of business for a few years dealing with my mom's issues. Got back. I was 13 years consecutive. Peace of mind, I can't tell you what value he brings. Great. Remarkable itself, right there. Great resource. I highly endorse him.
Thank you. I appreciate that. It's always nice to hear, and I appreciate it. And again, it is my goal to be a resource to the realtors, and I want the transactions to go well in our town, whether I'm involved or not. The goal is that we all get along, and I think it's working pretty well. I am going to quickly, because my syllabus, so to speak, said it, I'm going to just discuss two quick things. Again, if you have to leave, I respect that. The Homeowners Association rider, that's the quick, easy one. It is mandatory. You need to give the disclosure. The buyer needs to sign off on it. The critically important part, remember, I'm a loophole guy looking for ways out of contracts. If the buyer doesn't get this, they have 3 days from receipt of this document to cancel the contract. So if a buyer comes to me the day before closing and wants out of the deal, and I said, oh, it's a HOA, did you ever get the rider? No. Was it attached to the contract? No. Good, let's get the rider. Realtor, send me rider. Oh, there's the rider, we cancel. We got 3 days from receipt of this to cancel the deal. So get it on the part of the contract like you're supposed to. 3 days to cancel, nobody knows that. So the 3 days comes and goes, the right to cancel is over, and they've gotten their disclosure. So don't miss the HOA rider. It's that important, and it can kill it. You know, if you don't give it, it can bite you in the behind later. The condo rider's the same thing, only worse. Condo rider's got more stuff to fill in, and the law on the condo rider is in this paragraph 5. You either have acknowledged receipt of the condo documents, or you have 3 days from receipt of the condo documents to cancel. So the rider, in this case, the rider starts the 3 days. If it's attached to the contract, it starts that day. The condo rider, you have 3 days from receipt of the documents. And the documents aren't just the condominium documents. I'm going to read really quickly here, but the documents are Declaration of Condominium, Articles of Incorporation, Bylaws, and Rules of the Association, a copy of the most recent year-end financial information and frequently asked questions and answers document. You got to get all of those to the buyer, and the buyer has 3 days from receipt of those to cancel the deal, whether they get it today, tomorrow, or the day before closing. They have 3 days to cancel the contract. So again, buyers come to me, they want out of the contract. Did they ever get the documents? No. We go to closing. I walk into the closing and say, oh, can I see the condo documents? Ooh, I don't like this. We're out of here. And we get up and walk out, get our deposit back because we had 3 days from receipt of the condo documents. Close that loophole. Fill in the condo rider. I don't have time to go over it, but it's self-explanatory. Fill in the blanks on the condo rider. Fill in the blanks on the HOA rider. On the condo rider, in addition to filling in the blanks, make sure you give them the documents. If as a seller you can get away with it and have the buyer acknowledge receipt, all the better. and otherwise somehow, I don't care how you do it in your file, an email or whatever, but document the date you gave them the documents, or get an email confirming receipt of the documents, just something so I don't come along and say, did you get the documents? No, great. You can say, yeah, he did, here's a copy. And remember, if I'm on the seller side and I send them to you, the buyer received them. So when the buyer hires me, see how I switched that? When the buyer hires me, I have a conflict of interest. But assuming I wasn't the seller, and I say, did you get the documents? And he says no, and then I try to be fancy man, cancel the contract, and then the listing agent says, well, I gave them to the buyer, the selling agent, and they have an email proving they gave them to the selling agent. The bottom just fell out on my argument. You didn't give them the documents. And again, if there's a liability there or not, depends on how the rest of the story plays out. But if you receive them, give them to the buyer. If you don't get them, again, one of these little slimy things on my part, if you don't get the documents as the buyer, you don't have to go asking for them because you're leaving this loophole open. By the same token, you do want the buyer to review them. So a little bit of a catch-22. A lot of it you can get on your own, so it wasn't delivered. So again, I'm kind of going off gray area here. But as a buyer, it is a loophole until you get the documents. As a seller, you want to close that loophole by providing them, whether the documents is the actual form of rider, that's the whole thing, or whether it's the condominium documents. So with that said, I have now covered everything. I'm sorry I'm 5 minutes late, but I do thank you for the warm endorsement, and I will stay and answer any questions for you. And Zoomers, thank you, and I will look down and answer any questions here as well, assuming I know how.
Yes. Question on the disclosures. I've been told I also have to have my buyer do a buyer's disclosure.